100 watts. Page number 7. Serial number 5236.
Yes. Have you filed your objections? More important is filing objection, not wakalat. When will you file your objection? When will you file your objections? This week. 32. Then counsel for respondent number 1 and 2 submit that he has filed his wakalatnama and he seeks for a week's time to file his objections. Objections, if any, by 28, relist on 3rd. Yes. You are appearing for which respondent in which matter? For the petitioner. Mr. Shukumar, you are for the respondent. Shetty, you are also appearing in that? You are appearing for Mr. Shukumar. You are appearing for Mrs. Ramaya. 27. I submitted that the arguing counsel in WP number, arguing counsel for the petitioner in WP number 17375 of 2017 is unwell. Relist on 25, 27, 7. Everything. In your matter, Mr. Kumar? Yes. Interim order in WP number 23363 of 2021 is extended till next date of hearing. Sorry, 27th Agala, Mr. Shetty, it will have to be 26th. BDA matters. Except 26th.
Page number 8, serial number 37 to 45.
Yes.
Till number 41, my lord.
Just a moment. Has objections been filed? Sri T.N. Vishwanatha has entered appearance for the petitioner and registry direct delete the name of the Satish B as that appearing for the petitioner. They submitted that there is a bereavement in the family of the counsel for the petitioner and agreement is sought for relist on 8/8/2022. Objections of the respondent is not filed to be filed in the meantime.
Serial number 41, my lord.
Yes. Really?
Serial number 41. I think I pressed time. Serial is not well, my lord.
41. Learned counsel for the petitioner seeks for objections actually, right? And counsel for the petitioner seeks for and is granted 2 weeks time. We list on 2/8. Yes.
Much obliged.
2/8. Yes, 44. Our objections are alone. In time back, 44 and 45 learned counsel for the petitioner seeks for a short accommodation. Objections are yet to be filed on behalf of the respondents. Objections to be filed within a period of 2 weeks from today. Relist on 3 weeks from today. Relist on 16/8. Interim order earlier granted is extended. Objections are alone. For DP Prasanna, he is retired. He's filed a memo for retirement. Memo for retirement has been filed. Girish has entered appearance. A memo of retirement has been filed. Counsel for respondent number 4. The said memo is accepted. The DP Prasanna is discharged from the matter. Registry direct delete his name as that appearing for respondent number 4. Sri Girish Whereas counsel is directed to accept notice for respond number 4. Registry is directed to print his name as that appearing for respond number 4. Objections, if any, to be filed within a period of 2 weeks from today. Released on 16/8/2022. Yes. Are the objections filed by the other side? No. 53. Learned counsel for the petitioner seeks for a short accommodation. Objections are yet to be filed by the respondent. 3 weeks time is granted for objections to be filed. Released on 16/8.
Page number 10. Serial number 56 to 66. Page number 11. Serial number 67 to 77. Page number 12. Serial number 78 to 88. Page number 13. Serial number 89 to 96.
Income tax department is a party. Is it? 59. Learned counsel for the petitioner seeks for a short accommodation. Shri K.V. Arvind, the standing counsel, is directed to accept notice for respond number 3.
Cooperative Society and Karnataka Income Tax Department, House Building Cooperative.
House Building Cooperative Society, na Income Tax Department. So, seeks for a short accommodation. Released on 16/8.
Page number 14. Serial number 97 to 107.
98. 99. Yes. 99. It's submitted the arguing counsel for the petitioner is unwell and argument is sought for. Released on 23/8.
Page number 50. Serial number 108 to 112.
Yes.
For dismissal, serial number 1. CH-21 petitioner.
None appears for the petitioner. Despite notice having been issued and served, the office objections have also not been complied with. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
What was the address is next to petitioner?
And last one.
National serial number 2.
Given Niragi, the standing counsel is directed to accept notice for respond number 1, issue notice to respond number 2, returnable by 2/9/2022, released on 2/9/2022.
Serial number 3.
Yes. Srinivas Bhatt is directed to accept notice for respondent. Counsel for the petitioner to furnish copies of the petition along with annexures on the said counsel. Objections, if any, by 18/8, released on 23/8. 23/8. ಎಲ್ಲರೂ data. And AGA accepts notice for respond number 2. Shri P.P. Rajendra Kumar Sunde is directed to accept notice for respond number 1. Counsel for the petitioner to furnish copies of the petition along with annexures on said counsel. Objections, if any, by 19th, released on 23rd. ಏನ್ ಮಾಡಲ್ಲ ಕೊಡ್ತಾರೆ ಅವರೆಲ್ಲ ಮಾಡಾಗಿದ್ರೆ ಇನ್ನ ಬರತ್ತೆ 23rd. Hmm. 'Satyanarayana Reddy is directed to accept notice for respond number 1 and 2. Counsel for the petitioner to furnish copies of the petition along with annexures on the said counsel. Objections, if any, by 19th, released on 23rd August. The operation of the endorsement dated 4/7/2022, bearing number so and so, while annexure Y is stayed until the next date of hearing.
Yes. 10 and 11 minutes.
Fifteen and 16. When did you file the memo? 15th July. Okay. No idea. Counsel for the petitioner submit that he has filed a memo dated 13th July, enclosing the acknowledgement for service on respond number 15 and 16. Registry is directed to put up the same and relist on 2/8. It's objection. ಯಾವತ್ತು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಫೈಲ್ ಮಾಡಿದ್ರಾ? Twelve 3/21. 12/3 ಯಾವ್ದು ಇಲ್ವೇ? 11/2 is the last date. 12/3. Time is granted to file application. ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿದಾಗ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ ನೀವು? ನಿಮ್ಮ ವಕಾಲತ್ ಅಂದ್ರೆ ಏನಂತಿದ್ಯಾ?
ವಕಾಲತ್ ಫಾರ್ ಎಲ್ಲ ಪರಿಸ್ಥಿತಿ.
ಇದು ಯಾವ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಅವರು? ಪಾಶವು ಏನೋ when did he expire? When did the petition? When did the petitioner expire, Mr. Counsel? When did he expire? 10/5/2021. It stated that the sole petitioner, illa petition number 5 ಜನ ಇದ್ದಾರೆ ಇದ್ರಲ್ಲಿ. ಯಾರು? Who expired? Submitted that this first petitioner expired on 10/5/2021. Hence IA 1 of 22 and 2 of 2022 is being filed on 11/7/2022. to condone the delay and to bring the legal representative of the deceased, petition number 1 on record. Registry has raised an objection that an application setting aside abatement has not been filed. May counsel for the petitioner submit that the legal representative deceased petition number 1 are already on record, in as much as respondent number. Where is the record of? Where is she on record? The legal representative is already on record and Kerala. Already on record, therefore abatement illa andre. Elli the record alli. Does that have any nexus for abatement, Mr. Counsel? If 150 days have lapsed, you have to file a limitation, a condemnation of delay and abatement. ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ Learned counsel for the petitioner seeks for and is granted. Is granted 8 weeks to comply with office objection. Released on 10th October. ನೀವು ಕೇಳಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡೋಣ? ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅಂದ್ರೆ ಇಲ್ಲ. You have to file an application. Seeks for a week time to file an application. Released on 2/8. Very good. ಇವಾಗ ಫೈನಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬರ್ತಾ ಇದೆ ಎಲ್ಲದರಲ್ಲೂ. Mr. Gowda, Mr. Narendra Gowda. You bury the certified copy of Anishakti. And dispensation credit, right? You have produced it. The Adi Sadashiva, learned counsel for the petitioner, submit that the certified copy of Anishakti has been produced on. How was produced, Madhu? Illa, Mr. Sadashiva, it's not there on the file. Submit that he has filed the certified copy of Annexure K on 22/2/2021. If that be so, the office objection would have to be overruled. Registry to verify and released on 2/8. Interim order are granted with extent to next day. ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡಿ ಮ್ಯಾಂಡಮಸ್ ಬಂದಿದ್ದು ಅಷ್ಟೇ ನೀವು. You came for a mandamus, we asked you ಹೇಳಬೇಕು ಅಂತ ಎಲ್ಲರೂ ಕೊಡಿ ಅಂದ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Preferably within the set layout ಅಂತಿರಲ್ಲ. ಬನಶಂಕರಿ ಯಾವ ಸ್ಟೇಜ್? ಸಿಗಲ್ಲ Malale. Counsel for the respondent has filed a memo stating that Site number B4 SD 2001 measuring 30 by 40 has been allotted on 18/7/2022 in compliance with the order dated 14 June 2022. The said memo is taken on record. That counsel for respondent has also filed another memo enclosing therewith the steps which are proposed to be taken by implementation of the ERP project at the BDA. The said letter dated 18/7/2022 reads as under. Implementation ಯಾವಾಗ ಆಗುತ್ತೆ? It is stated that the e-office application would be implemented within 1 month at the BDA. And as regards other activities, by implementation of ERP project, tenders would be invited. Tender has already been issued. As published, tender has already been published and finalized. As also, LOA has been issued to the lowest quoted vendor, which would be approved, which would be placed for approval before the next board meeting. And the contract would be executed shortly. They stated that the same would take 40 weeks for completion from the date of awardal of contract. It is further stated that a help desk with a customer helpline number with multi-channel complaint registration facility by phone, SMS, online, email, Facebook, Twitter, and WhatsApp is also proposed to be established. But again, date ಯಾವತ್ತಾಗತ್ತೆ ಅಂತ ಬೇಕಲ್ಲ. ಸುಮ್ಮನೆ ನಾವು ತಗೊಂಡು ಹಂಗೆ ಬಿಟ್ಟರೆ ಅಲ್ಲೇ ಇರುತ್ತೆ. However, date of implementation has not been mentioned. Shri K. Krishna, Learned Council submit that the same would be implemented at the earliest. Relist on 5/6/9/2022 to report compliance as regards implementation of the e-office. ಅದು ಇದ್ರಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ, ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ ಅಲ್ಲಿ ನೀವು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಬೇಕು ಎಲ್ಲಿದೆ ಅಂತ. Mr. Prasad. Julius Prasad. Arun Kumar. You filed your objection, Mr. Ajay?
Because they have not served a copy of the petition.
Not served. None appears for the petitioner. Counsel for respondent submit that respondent number 1 submit that he has not even been served with the copy of the petition and annexures, though an order was passed to that effect on 7/6/2022. Relist on 16/8/2022. If none were to appear for the petition on that date, the petition will be liable to be dismissed for non-prosecution.
Serial number 12.
So the site, R3. So Karnataka Income Tax Department, ನೀವೇನಾ ಬರ್ಕೊಂಡ್ಬಿಡಿ ಸೈಡಲ್ಲಿ. Shri B.N. Prakash, Lieutenant Counsel, submit that he will be entering appearance for respondent number 3. Registry is directed to print his name as such. 12.1, Shri B.N. Prakash accepts notice for respondent number 3 and submit that he will be filing Wakalatnama for respondent number 3. Adrallu hakidra? Has filed Wakalatnama. 12.1 ali. Shri B.N. Prakash, Lieutenant Counsel, submit that he will be entering appearance for respondent number 3 also. Registry is directed to print his name as such. ಆಮೇಲೆ ಬರೋಣ ಇದು ಇವಾಗ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾವಾಗ ನಿಮ್ದೇನಿಲ್ವಾ ಮತ್ತೆ ಯಾಕೆ ಇವತ್ತು ಯಾಕೆ ಬಂತು 89 ಇವಾಗ 89 ಅಲ್ಲಿ ತಗೊಳ್ಳಿ ನೀವೇ ತಗೊಂಡಿದ್ದೀರ 18 ಅಲ್ಲಿ ಶ್ರೀ B.N. Prakash accepts notice for respondent number 5 has filed Wakalatnama for respondent number 3. Registry is directed to print his name as such. Registry is directed to connect WP number 9844 of 2022 with WP number 27754 of 2022. What about objections on your behalf? You have to file objections. When will you? Counsel for respondent number 2 seeks for and is granted 2 weeks time finally to file his objection. Objections if any by 5/8 by 12/8 released on 16/8. Actually memo asked. File a memo for dispensation, will dispense. But in dispensation, better a memo act.
May I make a mention?
Yes, Mr. Karthikeyan.
My lords, the copies have not been served on us.
Copy kotilla. Have you served the copy on Mr. Karthikeyan? Or illa anta idare. 13, Lieutenant Counsel for the petitioner seeks for and is granted a week's time to serve a copy of the petition along with annexures on the counsel for the respondent. Counsel for respondent number 2 is granted 3 weeks time thereafter to file his objections. Objections, if any, to be filed on or before 29th August, released on 6th September.
Grateful.
Yes. R5. This code 1. 5 ಯಾರು ಇದ್ದಾರೆ? This court, by order dated 7/6/2022, had permitted by allowing IA number 1 of 2022, had permitted the petitioner to take out subservice by way of paper publication. The memo has been filed. A memo dated 28/6/2022 has been filed, enclosing therewith the newspaper Vijayavani dated 22/6/2022, depicting the advertisement taken out. None has entered appearance for respondent number 5. Hence, service in respect of respondent number 5 is held sufficient. Registry is directed to print the name of respondent number 5 in the cause list with the endorsement. Service held sufficient through paper publication. R7 ಏನಾಯ್ತು? ಬಂದಿಲ್ವಾ ಇನ್ನ? Notice to respondent number 7 has been dispatched on 30th June, awaiting service released on 2/8. Registry is directed to place the postal tax receipt on that day. Whereas counsel for the petitioner seeks for and is granted 2 weeks time, released on 2/8. See. Planet Council for Respondent has filed a memo dated 19/7/2022 enclosing the endorsement issued by the petitioner, who has signed this. Wife of the petitioner, having received the sale deed, same is taken on record. Land Council for the petitioner seeks for and is granted 2 weeks time, released on 2 weeks. Or they are not able to contact and ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಅದನ್ನ ನಾವು ನಂಬ್ತಾ ಇದ್ದೀವಿ ಅಷ್ಟೇ. 2/8. Password. Mrs. Vanuja? ಬಂದಿದಾರಾ ನೋಡಿದ್ರಾ? Password? Password. ಏನ್ IF ಮಾಡಿದ್ರು? ಅವ್ರ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಟೆಂಡರ್ ಕರಿಬೇಕು. You verify and make it. Land Council for the Shri Rahul S. Reddy has entered appearance for the petitioner. Registry direct delete the name. Sorry, Shri Mithun GA has entered appearance for the petitioner. Registry direct delete the name of Shri Rahul S. Reddy as that appearing for the petitioner. It is submitted that an application has been filed to initiate contempt proceedings against the respondent. The said application has not been put up. Registry is directed to put up the same. Shri Unnikrishnan submit that he has received the copy of the said application and seeks for 2 weeks time to file his objections. Objections, if any, to be filed on or before 10th August, released on 16th August. Interim order earlier granted is extended till next day. Petitioner, the sole petitioner, is stated to be expired on 18/1/2022. View thereof, IA 1 of 2022 and 2 of 22 have been filed to set aside abatement and to bring the legal representative deceased petitioner on record. Excepting the reasons stated in the said application, the affidavit thereof being satisfied that the right to sue survives. IA 1 of 2022 is allowed. The abatement in respect of deceased petitioner is set aside. IA 2 of 2022 is allowed. The persons named therein are brought on record as petition number 1A to 1C. Counsel for the petitioner to carry out necessary amendment and file amended first title. Objections hakidara? Mr. Vachan? Amendment 1 week ಮಾಡ್ತೀರಾ? Counsel for the petition seeks and is granted a week's time, released on 26/7. Pass. And counsel for respondent number 3 seeks fund is granted 2 weeks time finally to file his objection. Objection is returned by 29th, released on 2nd. It is made clear that no further adjournment to be done. Hmm. Yes. You're arguing on the application or on the main?
Same issue is involved. Actually, the issue is not, the question is the 2019 amendment to the RMP. By virtue of which not certain additional FAR, etc. is made.
No, are you wanting to argue on IA or on the main? You're ready for the main?
No, I'm ready for main.
Ready for the main.
Oh,
What about you, Mr. Two thirty ತಗೊಳ್ಳೋಣ 230 ತಗೊಳ್ಳೋಣ ನಿಮ್ಗೆ ನೋಡ್ಬೇಕು ಅಂದ್ರೆ can wait for a week, Mr. Arun? It won't reach tomorrow and all that because tomorrow is not BDA day. BDA day is Tuesdays. Next Tuesday. Can wait till Tuesday? Right. The request of Sri Manjun Reddy, learned senior counsel appearing for the respondent, released on 26/7/2022 for hearing. Consideration of IA1 of 2022 would amount to consideration of the matter on merits. Hence, IA1 of 2022 would also be considered along with the main. Then office objections in Mr. Lakshmi. Bandidya. Learned counsel for the petitioner confirms receipt of statement for objections filed by respondent number 1 to 3. Hence, the office objection raised does not survive for consideration. At the request of Sri Manjun Reddy, learned senior counsel appearing for respondent number 1 to 3, released on 26/7. This is impeding application. For? Who are you, Mr. Chandrasekhar? Co-owner. How are you related to the petitioner? You want to file objections. That on merits we'll consider. If he is a co-owner, he is entitled to come on record. Why should we adjourn it only for that? You bring it on record. You can file your additional. They'll file objection. You can file your rejoinder. All those are open. So shall we refer it to mediation? Only then we can refer it to mediation. You record madmele. Yes. IA1 of 2022 has been filed by the impeding applicant, claiming to be a co-owner of the property and having filed a suit as regards the very same property which is pending in OS number 366 of 2018 before the senior civil judge and JMFC Anekat. In view thereof, I am of the considered opinion that the presence of the impeding applicant would be necessary to effectively and completely adjudicate on the list. As such, IA1 of 2022 is allowed. The impleading applicant is brought on record as respondent number 3. Counsel for the petitioner to carry out amendment and file amended cause title. Both the counsels submit that if the matter is referred to mediation, the possibility of a settlement being arrived at. Really, they are all in Bangalore. In view of the said submission, the matter is referred to mediation to the Bangalore Mediation Center. The director, Bangalore Mediation Center, is directed to appoint a suitable mediator to mediate the dispute between the parties. Since the order is being passed in the presence of both the counsels, the parties and or their parties with or without their counsels to appear before the Director Mediation Center on 1/8/2022 at 3 p.m. without awaiting any further notice. Released on 27/9/2022. Two times and 3 times agಬೇಕಲ್ಲ. Like address ilva? Then take and summons. Service to respond number 8 and 10 is awaited. The counsel for the petitioner seeks permission to serve take out and summons on respond number 8 and 10. He is so permitted. Registry is directed to issue necessary and summons to the petitioner for service. Released on 16/8. 16/8. BA. BS Sujata Leonard counsel submit that the name has been wrongly stated as BS Sujata. It should have been BA Sujata. Registry is directed to do the needful. Ready? ವಕಾಲತ್ಗೆ ನಿಮ್ಮ ಇನಿಷಿಯಲ್ಗೆ ಹಾಕ್ಬೋದಾಗಿತ್ತು. ಏನಿದು? ಆಟೋ ನೀವೇ ಅಲ್ವಾ? ಆಟೋ ನೀವು R1 ಸ್ಟೇಟ್. Sujata seeks for and is granted 2 weeks time to obtain instruction, make a submission, released on 2/8. Next week. Next week, ಯಾರಿಗೆ ಬೇಕು next week? ನಿಮಗೆ ಬೇಕಾ? ನೀವು ಈ ಕಡೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರಲ್ಲ. ಎಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ? On behalf of the counsel for the petitioner, a week's accommodation is sought for, released on 2/8. Charity, you are appearing now? Murgesh Charity has entered appearance for respond number 2. He accepts notice for respond number 1 and 3 also. Registry is directed to delete the name of Sri Rajaram as that appearing for R1 and R1 to R3, as also the name of HCGP as that appearing for R1, and print the name of Sri Murgesh Charity as that appearing for R1 to R3. Objections ಹಾಕಿದ್ದೀರಾ? ರೆಡಿನಾ? ಪ್ಲೇಸ್ ಮತ್ತೆ ಹೋಗಿ. ಡಬಲ್ ಅಬ್ಜೆಕ್ಷನ್. ಸೊ ಡಬಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದ್ರೆ ಡಬಲ್ ಡಿಸ್ಮಿಸಲ್. ಹೇಳಿ. Yes.
And he's going to say it was a period of 87. And subsequently, 1987, he paid entire amount into the put in possession.
Yes.
Thereafter, the notes of the fire, to get an agreement of sale and power of the developed second petition on 20.
Was there any restriction on sale?
We say that during the period of lease and sale,
What was the period of 1987?
there is no specific period. Period is not specific.
Not specific. Yes.
And the entire amount was paid.
Where is the lease come sale? Where is the allotment?
Allotment is initial fee. Page number. Initial fee is page 23.
Yes.
I remember I copied in page 24. These can say it's not the see of the page 26.
Where is the clause as regards the restriction?
Restriction clause number 28. Clause 28. In page 32. The receipt purchase shall not leave the pendency of this until the regular conveyance is contained by the receipt purchaser subject to such a covenant with the agreement of the lessor and
There is a restriction under Mr. Gogu.
the crime transfer or deed with is the right in favor of their parties and in favor of the third parties who are not parties to this condition. The receipt purchase shall continue to the lessor for all the
There is a covenant, negative covenant.
Event of such incident taking place without an allotment survey. Now, the provision provided that collecting of 25% of penalty towards the regular acquisition.
You purchased it in 92.
No, agreement of sale, power of attorney was given on 24/6/1990. Sale took place only in 15/6/2010.
So as on today's value, it has to be.
No, sir, allotment.
Why it should be that? You have come before this court now.
Representation was given.
What is your rule 70? Allotment of site allala, building allala. Building. Allotment of site is. Same book is there. 302. 302. Allotment of building, 17.
One capital name.
Beyond 10 years.
At the rate specified by a state government from time to time for the purpose of registration. Order for regularization of self-alienation. So when you come, that is the date on which it will have to be deposited.
And my representation was decided in 2015.
And when did you come before this court? 2016. You made your representation 2012. Yes, Mr. Charity, 2012. How can you make 2008? 2010 is your sale date.
Because the second petitioner, the power of attorney were being given a power to
Hmm.
seek and act on his behalf to represent the property.
Your vendor was allotted this building or apartment on an EWS category. Having got it under EWS category, he has sold it to you immediately thereafter. After ಎಷ್ಟು years? Yes. ಇವಾಗ ಅದಕ್ಕೆ 2010 ತರ್ತೀರಾ ಇಲ್ಲ ಪವರ್ ಆಫ್ ಅಟರ್ನಿ ಯು ಗೋ ಟು 92. So immediately after the allotment he has sold it, thereby depriving another EWS category person, which you were aware of. You have money, so you pay. Impound ಆಗೋಗತ್ತಾನಲ್ಲ ರೆಫರ್ ಮಾಡಿದ್ರು. ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸ್ಟಾಂಪ್ಡ್.
That was one of the requests that one of the requirements that was to board. He says is unavailable. We don't know where is going. Second aspect, before the sale could be made, but the award should be the permission from the PDA that this is an inevitable situation. Why as part of the property allotted within the prescribed period of the 10 years. We after the permission is given, then he can make an alienation. For that alienation, that's the 25% of the payment. Here, right away the alienation has been made. First, they refer to the rule 2 of the rule 11.
If we accept this, then there won't be any sanctity to that condition. There won't be a sanctity to the condition. Everybody will take one EWS, sell it off.
25%. And it is far more easy, but
It will become a business. People are waiting with 10 applications filed asking for allotment. So can we allow you to short circuit the whole thing?
Original award is not traceable. Public notice was given by PDA itself because after the CH-21 to produce original documents for connection.
ನೀವು ತರಲಿಲ್ಲ ಅಂದ್ರೆ 4 feet ಆಗೋಗುತ್ತಲ್ಲ, resumption ಆಗೋಗುತ್ತೆ.
Power of attorney is in my level in respect of
Power of attorney, if you rely on Mr. Kogi, we'll have to impound it. There's only one power. So we can't look at one clause differently, another clause differently. So if you are going to rely upon it, we'll have to impound. We are using it in a judicial proceedings. Stamp duty. If you also issued a public notice, nothing will happen, Mr. Chaudhary. 2012 ಲೆಕ್ಕದಲ್ಲಿ you value it and 25%. Hmm. Even till today, not satisfied. And he'll never be able to satisfy.
Wife executing the conditional agreement to sell in favor of the husband, but there it creates a doubt. Wife executes the agreement to sell in favor of the husband. That creates a little doubt. That's why we ask for not the original allotment. Not what happens with the original allotment, the wife takes in Parapata. And what says I am executing an agreement to sell in favor of the husband. But then they enter into, then the sale deed is executed by wife to the husband.
Agreement is by also people in favor of Sunita.
But
Sunita as a representative.
you have 2010 sale deed, who is executed in your favor?
Power of attorney holder.
Who is the power of attorney holder?
Therefore, both of them are right with the petition.
So where is Tirupatappa? Sale deed has not been executed by Tirupatappa.
Because he executed power of attorney and there was an agreement of sale, but thereafter he gone missing. All originals are with me. I produced before the authority. Therefore, they have issued a public notice calling for objections if any legal help to came in and Tirupatappa himself appears in the matter. He did not because his whereabouts are not known to us. Therefore, that is difficult. In fact, you know, it's an ordinary mention of the situation like this. Not have held that media have no authority to question the power of attorney when the not allotting himself.
If tomorrow Tirupatappa comes and claims against the BJ, you'll have to issue indemnity.
I am issuing. In fact, I have given indemnity affidavit also. It is
That
their
will,
part of
that will
the-
cover it. The most Tirupatappa can claim against you. That is if you come to clause 2. 1A was introduced by amendment, which is notwithstanding anything contained. So even if there's a violation, if 2 had been resorted to, there would not have been a violation at all. Yes, but 2 only violation ಆಗ್ತಾ ಇರಲಿಲ್ಲ. If 2 they have complied with, if they had complied with 2, then there wouldn't have been a violation to resort to 1A. 1A is only if there's a violation.
Violation is 1A.
Yes.
And permitted to read 2, then 1A.
Right.
Notwithstanding anything contained in these 2, where an authority makes an application to the authority seeking permission to sell the building during the lease period of 10 years, the ground that for reasons beyond his control, he is unable to reside in the city of Bangalore, or that by reason of his insolvency or insolvency, it is necessary for him to sell the building allotted. The authority may permit him to sell the building subject to paying with the authority an amount equivalent to 15% of the allotted value of the building. But
Either if he had applied, 15% ಆವಾಗ 1A.
But where notwithstanding anything contained in sub-rule 1, where an authority has delineated the building in contravention of clause A of sub-rule 1, the authority may on an application of the transfer of such building and subject to payment of such transfer an amount equal to 25% of the value of the building, determined at the rate prescribed by the state government from time to time for purpose of registration. Order for regularization of a sub-alienation and may also convey title to such transaction. Yes.
ಅಲ್ಲಿ 15% ಇತ್ತು ನಿಮ್ಗೆ, ಇವಾಗ ಅವ್ರ ವೈಲೇಷನ್ ಅದ ಇನ್ನ 10% ಎಕ್ಸ್ಟ್ರಾ.
Where allotted transfers, allotted that is the
ಅದಕ್ಕೆ ಇಂಡೆಮ್ನಿಟಿ ಕೊಡ್ತಾರೆ.
ಮಾಡಿ ಹೆಂಗೋ ಅವನಿಂದ ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಕೇಸಿಗೆ ಬಂದಿದ್ದೀರಾ.
supposed to get he himself then says, no, I'm unable to get him.
ಅದು ಯಾವ ಡೇಟ್ ಅದು? 2010 you made an application.
Yes.
21/8/2010.
Yeah, asked him to secure his presence. But that also is not done by him. But the date of the
So this public notice has been taken out by you at your cost or at his cost?
at our cost, because such an application is made, but then we'll have to be cautious.
But then that would have to be at his cost. That cost also you should be able to recover. Because it is on his application that you are incurring the cost.
Yes.
So 2012. So 2015 you rejected it after 3 years. So that cannot, you cannot hold him responsible for that. Your delay. You avate reject ಮಾಡಬಹುದು. You can't take 3 years to reject it also, Mr. Whatever the board takes is fine. Why it took such a long time? Yes.
ಇಂತಹ ಪ್ರಕರಣಗಳು ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಬಹಳಷ್ಟು ಬಾಕಿ ಪ್ರತಿನಿಧಿಗಳು ಸಾರ್ವಜನಿಕ ವರ್ಗಾವಣೆ ಮಾಡಿ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಶುದ್ಧ ಪಡೆಯಲು ಮನೆ ಫ್ಲಾಟ್ಗಳನ್ನು ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡುವುದಾಗಲಿ ಬ್ಯಾಂಕಿನಿಂದ ಸಾಲ ಪಡೆಯುವುದಕ್ಕಾಗಲಿ ಅಥವಾ ಇತರೆ ಯಾವುದೇ ಉದ್ದೇಶಕ್ಕಾಗಲಿ ಸಾಧ್ಯವಿಲ್ಲದ ಕಾರಣ ಈ ಬಗ್ಗೆ ಅಗತ್ಯವನ್ನು ತೆಗೆದುಕೊಳ್ಳುತ್ತಾರೆ. ಇಂತಹ ಪ್ರಕರಣಗಳಲ್ಲಿ ಉಂಟಾದ WC ನಂಬರ್ 9 ದಿನಾಂಕ 2013 ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಆದೇಶಿಸುತ್ತದೆ. The validity of the otherwise duty under the petition exercise of his power vested in him and the general power and executed by the allotting principle of freedom in his favor and not questioned by the authority. It is not known as to what the authority
This circumstance, present applicant that is purchase of property from lessee did not derive any right or title against the BDA, and BDA can execute sales only in favor of the original allotee and hold ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿ ಅದು ಕೊಡಿ. Goes against you. What is this other? What is the next page?
legal opinion.
And after that, they have come to a conclusion that maybe that proposal in the case. Last time.
The board took a decision not that to go after the opinion.
This is only your opinion. The judgment is different. Judgment is against you. You'll have to go by the judgment, not by the opinion.
But here, Lord, here he was virtually like a tenant of the house, the building which was allotted to them.
You had the power to forfeit and resume. You have not done it. They have come for regularization, we can regularize because you are not exercising your power. If you had exercised it, that was different. You cannot now say when he applies for regularization that I have the power. You missed the bus on that.
At least, the date of the payment, or at least 25%.
2012 is the application. You can do it today.
2012, but I agree that they have made an application for transfer. The fact that if at all the petitioner had fulfilled the condition as getting the original owner.
2012, he made the application. You passed an order in 2015. He has filed this petition in 2016. Petition has been pending for 6 years. He is not to fault for that. If he had filed the petition now, we can agree with your submission. He's been waiting for 6 years for various reasons. We cannot impose interest on him for that reason. He is right. He has come in 2012. 2012, it could have been considered. So,
Yeah. Further proceeded after the for many states, 2015 in the date. I guess I learned that.
because he did not satisfy the entire process.
Yes.
The petitioner is before this court seeking for the following reviews. House number 86 at second stage Kumar Channel Layout, Bengaluru was allotted by the second respondent BDA in favor of one V. Tirupatappa under the Woodco scheme on 24/11/1994, and a lease cum sale agreement came to be executed on 31/8/1987, in persons of which the said Tirupatappa had been put in possession of the property. On 24/6/1992, V. Tirupatappa had executed an agreement of sale and power of attorney. On 24/6/1992, it is claimed that V. Tirupatappa executed an agreement of sale and power of attorney in favor of the second petitioner. In pursuance thereof, the second petitioner executed a sale deed in favor of the first petitioner on 15/6/2010. The petitioner thereafter made a representation on 21/8/2010, seeking for execution of sale deed and transfer by the BDA in his favor. An affidavit was submitted on 23/12/2011. Acting in pursuance thereof, since the original allottee had not approached the BDA issued a public notice dated 18/1/2012, calling for objections, if any, to a transfer. Thereafter, taking into account that the GPA was executed in the name of the wife of the first petitioner, and the wife had executed a sale deed in favor of the first petitioner, and the sale not having been executed by the original allottee Tirupatappa, the BDA in its meeting held on 23/9/2015 rejected the request of the petitioner, and it is that order which is under challenge before this court. Sri Santosh Gogi, learned counsel of appearing for the petitioner, by relying on Rule 17 of the BDA allotment of building, etc., Rules 1982, submit that if there is a violation of the non-alienation period, the BDA could collect 25% of the value as on the date of the application and regularize the sale, which has not been done, and it is in that background he is seeking for the reliefs as aforesaid. Shri Murugesh Charati, Learned Counsel appearing for the respondent BDA, could however submit that the allotment which had been made to Tirupatappa was under the EWS scheme. The allotment, it is for that reason that there are restrictions which are imposed under the lease agreement. Violation of the lease agreement would go to the root of the matter. And in this case, since Tirupatappa himself had not approached the BDA, and there being doubt as regards the power of attorney executed in favor of the second petitioner, wife of the first petitioner, the sale deed has not been executed. He submits that the penalty would have to be calculated on the date of break rather than finding go. He therefore submits that the petition is required to be dismissed. Third, Shri Santosh Gogi, Learned Counsel appearing for the petitioner, Shri Murugesh Charati, Learned Counsel for the respondent, produce papers. Rule 17 of the BDS also reads as under. The relevant clause under the lease agreement which prohibits the transfer, being clause 28, page 33, reads as under. Correct. A perusal of clause 28 and reading clause 28 in conjunction with Rule 17 would indicate that the allottee is prohibited from selling the allotment made or the property covered under lease cum sale until a conveyance is executed in favor of the allottee by the BDA. In the present case, admittedly, there is no such conveyance executed by the BDA in favor of Tirupatappa. And Tirupatappa executed a sale deed, an agreement of sale with a power of attorney and put the petitioners in possession of the property in the year 1992. Thus, the alienation, this is what is claimed to be an alienation by the petitioner. And subsequently, the same is fructified in a sale deed executed by petition number 2, acting as a power of attorney holder of the allottee Tirupatappa in favor of the first petitioner on 15/6/2010. I am of the considered opinion that the agreement of sale and power of attorney cannot act as a conveyance. The conveyance having occurred only on 15/6/2010. Whether the conveyance is a valid conveyance or not, whether the power of attorney was authorized to execute the sale deed in favor of the first petitioner or not, is a matter which the BDA cannot be concerned with, as held by this court in the decision dated 24/1/2013 in WP number 44813 of 2012. In the event of any dispute being raised by Tirupatappa at a future point of time, the same would have to be answered by the petitioners, and that is a dispute between them. Insofar as any liability on part of the BDA is concerned, the same can be counterbalanced by way of issuance of an affidavit by the petitioners in favor of the respondent, BDA agreeing to indemnify any losses that may be caused to the BDA on account of any such claim by Tirupatappa. 17(1)(a), Rule 17(1)(a), here now reproduced, indicates that if there is a violation by the allottee, then 25% of the value of the property of the building determined at the rate specified by the state government from time to time for purpose of registration would have to be collected by the BDA for regularization of the sub-alienation and thereafter convey title to such transferee. Is that since the rule provides so, there is no discretion vested with the BDA if such an application has been filed. The matter would have been different if the BDA had initiated action against the purchaser and or the allottee prior to such application for regularization having been made for resumption of the property allotted and for forfeiture of the amount paid. That right conferred under Rule 17(1), not having been excised by the BDA, and an application under Rule 17(1)(a) having been filed by the petitioner, it is required of the respondents to consider the said application in terms of Rule 17(1)(a) and collect the regularization fee fixed at 25% as detailed above and effect conveyance of title to the petitioner. Correct. In view of the above, in the present case, the transfer having occurred on 15/6/2010, it is the set date which would have to be taken into consideration for the purposes of considering a violation of Rule 17(1)(a) and the value fixed by the building by the state government as regards the property and as may be determined in accordance with, and the construction as may be determined on the basis of the CPWD rules would have to be taken into consideration for levy of the 25% regulation fee. Hence, I pass the following order. The writ petition is allowed. The certiorari is issued. The endorsement dated 23/9/2015 and Annexure S is hereby quashed. The respondent BDA is directed to collect 25% of the value of the property, including the building, as on 15/6/2010, and execute necessary conveyance in favor of petition number 1 within a period of 3 months or ಕೊಡ್ತೀರಾ ನೀವು ಬೇಗ ಕೊಡಬೇಕು the said payment to be made within a period of 8 weeks from today. BDA to execute necessary conveyance within a period of 8 weeks thereafter. Mr. Ahmed?
Ask the question.
None appears for the petitioner today. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 2/8/2022.
For the petition in this case, my lords.
Yes.
The petition in this case, my lords, in this petition, have challenged the endorsement issued by the BDA at Annexure J.
Mr. Vachan. Where is Mr. Vachan? Vachan, Mr. Charity. Pass over, Mr. Ahmed.
Blessed.
Mr. Abhinay. Publish is active, Mr. Here is that. None appears for the petitioner. Released on 2/8. Vaishali Agde, active objection. Lata Shetty, you filed. Reshma Tamaya, R4. R2 ಹಾಕಿದಿರಲ್ಲ ನೀವು. Shri K. Krishna seeks for and is granted 2 weeks time finally file his objections. Objections, if any, by 29th, released on 2nd. Second.
32 attend, 33.
Mr. Gopi, you file your objections? You don't need to file objections.
They are not even addressed to me. They have wanted to demolish, they don't need to expire. And then, after my repeated request, they served me this copy. Next week. They not even addressing. They are not serving me.
Is this a layout which is being formed by you, or what is this? Where is this located? Property?
There is no name of the petition.
Page?
That is the exact copy. Page number 2 is the correct copy.
Yes.
14 is take the copy, 13 is the photocopy.
Grievance is that he has not been issued in his name. Issue it in his name and hear him. You will treat it as issued to you. So called notice, you reply. Yes.
Let them not take any.
Until an order is passed thereon. No action.
That is not as if.
You cannot go anywhere. Your property is there, construction. You will have to sale it, whether it was a land which has been acquired and they executed sale, but I will not go. Got it. The petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of property bearing number 5 formed out in assessment number 39/3, situated at Shankara village, Kasba Hubli, Bangalore North Taluk, Bangalore, which is stated to come within the jurisdiction of Growth Bangalore Mahanagar Palike, ward number 32, Kaval Bhairasundra ward, Bangalore. A notice has been issued by the petitioner at the property on 13/11/2017 by the BDA, claiming that the said property is BDA property. It is in that background that the petitioner is before this court seeking for the opposite relief. Shri S.V. Prakash, Learned Counsel for the petitioner, would submit that the said notice is not addressed to the petitioner, but action is proposed to be taken against the property of the petitioner. Therefore, the said action on part of the BDA is illegal and cannot be countenanced either in law and facts, and as such, the petition is required to be allowed. Sri G.A. Gopi, Learned Counsel for the respondent, fairly submits that though the said notice is not addressed to the petitioner could reply to the same, which will be considered by the BDA on merits by affording an opportunity to the petitioner of being heard. In view thereof, I am of the considered opinion that the grievance of the petitioner is addressed by submissions made by Sri J. Gopi. Hence, I pass the following order. The notice dated 13/11/2017 bearing number so and so issued by second respondent at annexure A is treated to have been addressed to the petitioner. The petitioner is granted 4 weeks time to reply to said notice, enclosing all relevant documents. The respondents to also make available documents as regards the claim of the respondent on the said property to the petitioner. Respondent to provide an opportunity of a hearing to the petitioner and thereafter pass necessary orders. Needless to say that until such orders are passed, the respondent shall not interfere with the possession of the petitioner and or disposes the petitioner from the aforesaid property. Sorry, in this matter? Yes. Okay. Interim order agar extend madad bada. One thing is only.
The other matter is regarding challenge to the explanation.
Bank guarantee for what?
They are containing they have carried out the work for widening of the road in favor of the BBMP. What they have required, we have one Kuta supplied to the BBMP for widening the road. Instead of arguing to widening the road in that Kuta supply, the petitioner is the first petitioner. He said, partner in the elected member of the apartment. He carried out the road work in the to the benefit of that apartment instead of giving to the carrying out the work in the Kuta supply given by the PDA. He carried out in another land which is to the beneficiary to the therefore we protected another formulation. So now he is claiming that he has carried out the work and is claiming for free. Still land is banded with the PDA.
It's all disputed questions of fact.
Yes.
But like only we should have done we actually constructed the property, there's no enforcement as stated by them.
If you say this, if they say that we cannot adjudicate that in a writ petition, your contract, if any, will have necessary redressal mechanism. You have to resort to that.
There's no illegal encroachment. The inside construction done by us was taken out of the notice to the party. In fact, the resident of 8018 had written a complaint to them saying there is no reason for what it just came one day about and destroyed the entire day it was created by the contractor. There was no basis for that.
There is an illegal construction that they have claimed. What is the relief in the next matter? 8018.
Yeah, the partner of the same apartment.
No, but they just site owners never. Because 8018 petition, we have asked for the restoration of the land to what it stood before the demolition.
Madam, it is the same council who files both the petitions.
Yes, my lord. In fact, it is in the other matter, my lord, this is in 2018 that this construction encroachment happened sometime in 2018, my lord. The destruction. The alleged encroachment by the
Who are you in the third petition?
They are thinking that the owner of that required property and challenging the future.
they have no subsisting right, my lord, that is subject to the decision of the other petition.
Your other writ petition have nothing to do with
Yes, my lord.
land acquisition. Your first petition is as regards any claim that you may have to restore the land and survey. You should recommend the date are on the wide and so on.
The second petition is not, she is not owner of that property. They are claiming that the property given by the BDA to the BBMP after acquisition of the widening of the road.
Is BBMP a party?
BBMP.
What do you say? Who is BBMP? You are appealing.
Okay.
But the property is the same in all three. So who is the owner of that property and what? Yes, Mr. Puttegoda? No.
The corporation was doing the election, my statement of the PI, they have not
So you have filed impleading application. So we'll allow the impleading application in place. So we can. It's the same property, madam. He is the one who is challenging the acquisition. The first petition we'll have to dismiss. In the second petition, we'll allow them to come on record. Whatever claim that you may have against the BDA, please approach the adequate court. It's you. 8017 of third.
Yes.
Madam.
Our deposit is still with them.
Yes.
So around 1 lakh.
8017 of 2018. The petitioner is before this court seeking for the following reliefs. The petitioner claims to be a class 1 PWD contractor who has undertaken work for various government departments. It is contended that respondent number 1 had originally acquired the land in survey number 220 in the year survey number 220 where? Which village? 220 Baneswadi village, Kiarpura Mobli, Bangalore East Taluk in the year 1990, which came to be subdivided. Respondent number 2, West Bangalore Mahanagar Palike, had sought for widening of the existing drainage. Acting on the same, respondent number acting on the representation of respondent number 2, respondent number 1 BDA, he stated to have handed over certain vacant land for purpose of road widening and construction of drainage measuring 2 guntas. The petitioner claims that the petitioner was a successful bidder in the tender invited by respondent number 2, undertook and completed the work. In terms thereof, two bank guarantees had been furnished to the respondent number 2, and though petitioner has completed the work, the respondent number 2 had not made payments of the monies due. It is contended that on 9/2/2018, respondent number 1 removed the construction put up by the petitioner and thereafter put up a barbed wire fence on the stone poles put up on the said 2 guntas. It is in that background that the petitioner is before this court seeking for a mandamus to restore, seeking for the reliefs as aforesaid. What's your name, madam?
Marsha.
Ms. Marsha, learned counsel appearing for the petitioner would submit that the works have been carried out by the petitioner. Respondent number 2 is required to make payment of the monies due, and respondent number 1. Yes.
Where we have increased what they have not carried. So, according to them, where work they have done, we will be removed.
Yes.
Therefore, we have to work with the
EMD.
bank and EMD.
Make payment of the money due and respondent number 1.
1, to restore the construction put up by the petitioner. The K. Krishna Learned Counsel for the respond number 1 would submit that the construction was not put up in the 2 guntas of land which was made available by the BDA, but was put up for the benefit of an apartment. ಅಲ್ಲ ನಿಮ್ದು ಕೊಡ್ಲಿಲ್ಲ ಎಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದು ಅದೇ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ
We have done the construction as stipulated in the rules. At page number 47. The construction was completed in the subsequently at page 49.
It has been removed.
55. They are taking down the entire construction.
Yes, these are all disputed questions. Not in the area of demarcation, 2 guntas of area.
Which was made available by the PPA, but was put up for the benefit of the apartment.
The apartment situated thereafter. And as such, he submits that the said construction being illegal and unauthorized, the BDA had to take necessary action and demolish the. Who removed it? ಅಲ್ಲ ಕಲ್ವರ್ಟ್ ಎಲ್ಲ ಇದ್ದು ಡ್ರೈನೇಜ್ ಹೊಡೆದಾಕಿದ್ರೆ ರಿಮೂವ್ ಆಗಿದೆ ಅಲ್ಲ ಹೂ ರಿಮೂವ್ ಇಟ್ stop the work and remove the construction. Shri K. N. Puttegoda, Learned Counsel appearing for the BBMP, also submits that the construction which had been made was not on the area allocated by the BBMP, and as such BBMP is not required to make payment of any monies. Both of them are saying the same thing. What to do? The conspectus of facts as above detailed indicates that there are several disputed facts as regards the claims made by the petitioner and the claims made by the respondents. When there are such disputed facts, this court could not, in exercise of writ jurisdiction, verify and identify what is the actual status and determine if there is any amount which is liable to be paid to the petitioner or not. The petitioner would always have a remedy to approach to initiate civil proceedings and or recovery proceedings against the respondents if so advised. Hence, reserving such liberty, the petition stands dismissed. Impleading application does not arise for consideration and as such is withdrawn. What is 8018?
Along the fourth cross road and also signs.
What is your objections to this, Mr. Krishna?
Restore the land. She has to establish ownership of the land. She is not the owner of the area where the site was carried, the work was carried out.
What is your claim over 222B? What is your claim?
I'm resident on that fourth cross road. The road was given for mining purposes by the interest.
So at the most, it can be regarded as a public interest litigation. What is your private interest in this?
Because I have not been able to access my property as well as a result of this. There are
Because
certain laws that are mentioned.
they removed what was constructed next to your apartment.
Yes, sir. I'm not able to access my property as well.
By your, that construction was put up by your friend in the first petition.
No, thank
This is the way to do it, madam.
you. I believe you get submissions.
You cannot use public funds for your private benefit. Yes, Mr. Pottegowda, what is your submission?
Second one, third one, and
Second, yaar idare?
Anand, Arpit, third one, Amit,
Puneet, what are you saying? You claim your. Then you file your objections. See, IA number 1 of 2019 has been filed by a person claiming to be the owner of the land in survey number 220B, Manaswadi village. Since the taking into account the reliefs which have been sought for in the above petition, being of the opinion that the impeding applicant would be affected by any orders that may be passed in this petition, IA 1 of 2019 is allowed. The impeding applicant is brought on record as respondent number 3. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Objections. Petitioner dia copy. Counsel for the impeding respondent number 3 confirms receipt of the petition and annexures thereof. He seeks for and is granted 3 weeks time to file his statement of objections. Objections, if any, by 12/8, relist on 16/8. 5334. Interim order earlier granted is extended. What have you sought for in this? You have to file your objections. 34.2. Learned counsel for the petitioner undertakes to furnish a copy of the petition along with annexures on the counsels for the respondents who seek for and are granted 3 weeks time to file their respective objections. Objections, if any, by 12/8, relist on 16/8. Interim order earlier granted is extended. Friday, yake? Ina. Murgeshwarati seeks for and is granted a week's time finally. Relist on 26/7. Counsel. Counsel for the petitioner seeks for and is granted 2 weeks time to file his rejoinder to the statement of objection. Rejoinder, if any, to be filed on or before 12, relist on 16. So Shiv Shankar. Despite the order dated 14/6/2022, and the earlier orders, today also none appears for the petitioner. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Actually, copy not.
And regarding the fact of this matter, the second set instructions of the party because we think not it should be. Once I've already become instructions, she just ascertain what you are seeking this petition is, and mandamus to the BMRC.
Not to carry out any works.
Yes,
Ago
the BMRC in fact has carried out certain works.
yaar BMRCL yaar. You are appearing. We'll record his submission and dismiss.
Because this is 4,000 square area. Has been in fact murdered by people that has been acquired. And not in fact even deposited anything, no notice, nothing. This petition was filed much before the in fact murder. Any acquisition proceedings were initiated.
You yourself have admitted that they have raised the compound wall. Then you direct the respondent to not to carry out works. I don't know. If compensation, if there is any compensation amount that you have to recover, you can go before the concerned authority.
Before that, in fact, compound wall now, the second prayer also not survived.
Your second prayer is contradictory to the first prayer.
But they still store certain items in the remaining property because this property measures about 20,000 square feet.
Whether the compensation has to be issued by the petitioner or the BD, because it is the CSI. CSI portion was notified and required. Then the compensation is concerned because it is the CSI. The BMRs have deposited the compensation with the BD. Now, because the petitioner is only the lessee.
That I do not say in the statement of objection so that I can.
No, your reliefs are only for this. You are not even challenging that. Both the aspects that Mr. Krishna is replying to your contention, but your contention has not been raised in the petition. Your contention is only as regards not to carry. So if you have something, please gather the details and file your petition for that. Then you will answer and we can consider. Not in this. I will put, we can't direct in this petition. We will request Mr. We can't on record direct it. We will request Mr. Krishna to give it to you. Portfolio. But your relief is something else. Petitioner is before this court seeking for the following reliefs. Shri K. Krishna, learned counsel, who appears for respondent number 3, against whom the aforesaid reliefs has been sought for, submit that the works have already been completed by respondent number 3, and there is nothing which should survive for consideration in the above matter. Learned counsel for the petitioner submit that compensation amount is yet to be received by the petitioner. If that be so, it is for the petitioner to take appropriate action in appropriate proceedings. Reserving such liberty, the petition is dismissed as impracticed. Mr. Somya ji.
I appear for petition this case, Your Lordship.
Yes, Mr. Venkatesh.
Serial 40. In this case, Your Lordship, the fourth respondent is a society which has formed a layout, Your Lordship. As per the work order, they have not provided the STP and other facilities also, Your Lordship. And moreover, presently the property falls within the BDA limits, and BDA is collecting the property taxes, and it is not maintaining the layout, Your Lordship. In that context, we have preferred this petition.
The layout been handed over to the BDA.
Yes, relinquishment deed is executed in favor of BDA.
Relinquishment deed for what? Yes, Mr. Lakshmesh, has it been handed out? You are for? R4. So you are the one who has to do everything. So you are the villain of the piece. You are maintaining. Contextually, it is not being maintained.
Ma'am.
The STP cannot go to you. No water facilities, water facility is what? BWS has been party Mandila. Has not been installed, we have not collected, was not. Mr. Venkatesh, all these reliefs are as against your respondent number 4, who is a private party.
Yes,
That
Your
is
Lordship.
a contractual arrangement with them.
No, Your Lordship, we have purchased the site from them, Your Lordship. May I request Your Lordship to page number 39.
Yes.
39 is a work
so
order.
Far as what is being handed over to the BDA are the roads.
Yes, Your Lordship.
And the parks.
Yes, Your Lordship.
And civic community. Civic community,
Yes.
they'll allot to somebody. Park, they'll have to maintain. Your roads and drainage, they'll have to maintain.
Your Lordship, the streets also, streets lights, they have to maintain, Your Lordship, because they are collecting the property taxes, Your Lordship. Section 28A of the BDA Act, they have to, because they are collecting the taxes. If so, Your Lordship, kindly, if you are paying
Mr.
property
Venkatesh,
tax to BMP.
Listen to understand, please. Please listen.
Yes, Your Lordship.
Your road, culverts, drainage, electricity. Electricity are not one. BESCOM. Electricity goes to BESCOM. Sewerage goes to BWSSB. May not made them a party here.
May make one submission, Your Lordship. We are not on the point that electricity, we are on the point that these lights have been laid down on the streets, that power charges of the lights has to be borne by the concerned local authority, Your Lordship. As of now, to this property, the local authority is BDA because it is collecting the property tax, Your Lordship. In that context, I'm saying, with and second point, Your Lordship, even the fourth respondent, the society has not provided this STP, sewage treatment plant. On the previous occasion, the learned senior counsel, Mr. Suman, submitted this, represented that that machine has been laid, but it is not working. But as of according to the information and also provided to me, they have not put any machine over there, Your Lordship, but simply they have dug the pits, Your Lordship. In that context, may I request Your Lordship to page number 39.
File your objections, Suman?
Suman, sir, had filed objections, Your Lordship.
What have you say? What have you produced to show what you have done?
And you.
For what? For getting a consent. Where have you produced anything for that? In 2008, you have deposited to 20 lakh rupees with the Pollution Control Board. That's all. What happened to this consent? Have you established the STP? Is it working?
It is functional, but it's not fully operational. Because if it is fully operational, then the 70% of the sites are occupied.
Till then, what do people do? Had you told them that until 70%, I won't give you STP?
No, my lord, right now, 50 hours are being constructed. So the sewage is actually no.
Then get a BWSSB connection. You are required to do it. NGT's order, you have to establish the STP now.
I request Your Lordship to page number 39, Your Lordship. Only one
submission. Just one more message. The grievance of the petitioner is that there are no water facilities provided to, no drinking water facilities or water supply facilities. You place it on record. You have not placed anything. No drinking water facility and water supply facility. requiring the residents to purchase water through water tankers. There's no sewage treatment plant which has been installed and functioning in the property, in the layout. The waste generated is not collected, and the association has appointed external agencies to collect the waste generated. The parks are not being developed and maintained. Though the street lights have been installed, the street lights are not being maintained. And it is on that basis that it is claimed that necessary directions have to be issued to the respondent BDA. Correct. Insofar as the drinking water facility, sewage treatment plant, and waste collection, and they consider opinion that it is for the fourth respondent to establish by production of necessary document as to what are the actions taken by the fourth respondent in relation to those items. 2 weeks' time is granted to the fourth respondent to place on record the said documents. As regards the parks and the roads, the BDA, the said park and roads have been relinquished to the BDA. It is for the BDA to maintain the parks and the roads. 2 weeks' time is granted to the BDA to place on record the actions taken by BDA in that regard. As regards the street lights not working, it is for the petitioner to follow up the same with the BESCOM authorities.
Not with respect to not working, Your Lordship. May submitting that the street lights charges are paid by the welfare association, Your Lordship. That has to be paid by the, that's what my submission, Your Lordship.
If it is,
lights are there. We are the association is paying, Your Lordship. Street light.
You got a meter for the street lights.
Generally, yes, Your Lordship, they are paying that. That's what it has been told, Your Lordship. The street lights, they are paying the charge.
Meter for the street lights.
That's what it was told, Your Lordship. The street lights are being paid by us.
Is it a gated community?
Yes, Your Lordship, gated community.
Then you maintain it, Mr. Venkatesh. If the gated community is not a public access, then you have to pay the money for it. That is why there is a separate meter installed.
Well, that I will inquire and get back that on that point.
As regards the street lights, on inquiry sheet, T.S. Venkatesh Leonard Council submits that the petitioners is a gated community. Then BDA is not required to maintain your roads also.
Your Lordship, may I request page number 39 in that the
it's not a public thoroughfare. Are you going to give it as a public thoroughfare?
Yes, Your Lordship, the public thoroughfare is there, Your Lordship, because that the road has been relinquished, that kind of public only. That's public.
Is it a gated community or a public thoroughfare?
No, it's a public thoroughfare, but for the sake of safety measures, they have put the gate, Your Lordship. That's the only.
You
issue.
cannot put a gate.
Yes, Your Lordship, that we are aware, Your Lordship, that we are.
You cannot put a gate.
Yes, Your Lordship, that we are aware. Only.
On inquiry as to whether Sri T.S. Venkatesh Leonard Council submits that the roads and the street lights are not being maintained. So also the parks are not being maintained. On inquiry, he submits that it's a gated community. If that be so, it would be for the welfare association and or the developer to maintain the roads, parks, and the street lights. The obligation of maintenance of the roads, parks, and street lights of a gated community cannot be imposed on the BDA, since the same is not available for the public to use. The Lakshmi Rao Leonard Council for the BDA is directed to submit a report as regards whether the property is a gated community or it is, or the roads provide for a thoroughfare as an access to the general public. Learned Counsel for the petitioner also to place a similar report. We list on 3.8. With a gated community, you have to do it, Mr. Venkatesh.
No, it's relinquished because they are collecting the property.
Relinquishment ಮಾಡ್ಬಿಟ್ಟು ನೀವು lease back ತಗೊಂಡಿರ್ತೀರಾ. Actually ತಗೊಂಡು gated ಅಂತ ಹೇಳಿದ್ರೆ ಮುಗೀತು. You will have to maintain.
I'll inquire and get.
Yes.
Respondent number 3, my lord.
Yes. Respondent number 3 in 42.
For respondent number 3, my lord.
You are appearing for 4, Mr. Balagangadhar.
Sorry.
Here.
Beg your pardon.
Yes, Harish. Vanaja or Elli?
My lord, may I submit, my lord? My lord, your lordship heard us, and my lord, for BDM was directed to produce the modified plan. My lord, if Madam produced or made available one copy of the same, we will further submit. In the meanwhile, my lord, I also my learned friend Mr. Harish, we are neighbors. If there is any chance of some settlement, some space between the properties, it can be worked out. But at some breathing time, I will also inform Madam Manaja to produce the modified plan.
Mr. Harish is saying this court may refer the matter to mediation.
Oh, very well, my lord. Very well. Because, my lord, my prayer is there is one criminal cases also between the parties. You know,
Nodi, ಏನೇನಾಗುತ್ತೆ ಆಮೇಲೆ ನೋಡೋಣ. Compoundable, not compoundable, ಆಮೇಲೆ ನೋಡೋಣ.
ಆಗ್ಬೋದು. You ತಾವು ಅಪ್ಲೈ ಮಾಡಬಹುದು.
42 Shri K.S. Harish, learned counsel for the petitioner, and Shri G.S. Balgangadhar, learned counsel for contesting respondent number 4. Submit that if the matter is referred to mediation, there is a possibility of an amicable resolution of the dispute between them. In view of the said submission, the matter is referred to the Bangalore Mediation Center. The director of Bangalore Mediation Center is directed to appoint a suitable person as a mediator to mediate the dispute between the parties. Since the order is passed in the presence of both the counsels, the parties, with or without their counsel, to appear before the mediator, before the director of Mediation Center on 1/8/2022 at 3 p.m. without awaiting any further notice. Relist on 10/10/2022. 11/10/2022. Aircraft order. Income tax. Aircraft awaiting service on respondent number 4. Respondent number 4 served. AD Vijay illa ivaga. Shri AD Vijay is no longer on the panel of the Bangalore Development Authority. Hence, Shri Ajay Kumar then is directed to accept notice for respondent number 1 to 3. Counsel for the petitioner to furnish copies of the petition along with annexures thereof on the said counsel. Registry is directed to print the name of Shri Ajay Kumar as that appearing for R1 to R3 and delete the name of Shri A.D. Vijaya as that appearing for R1 to R3. Objections, if any, to be filed on or before 18/8/2022, relist on 23/8. First notice ಹೋಗ್ಬೇಕಲ್ಲ, ಅದು A.D. Vijaya is no longer. Yes. 47 ನಿಮ್ದೆ Mr. Gunjal. Mr. Gunjal, ನಿಮ್ದೆ 47.
She is waiting for allotment site methods. And she has made more than 6 attempts. 7th attempt also they say they will give it, but it's not being allotted.
ಇಲ್ಲ ನೀವು ಏನೋ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ. She ಅಲ್ಲ, he is.
Applied for the second year 2002 and when the site was allotted to him, he has.
In this case, my lord, what happened, my lord? The petitioner here is a scheduled caste, my lord. He had applied for the plot
And he could not pay the amount in time. It was terminated, my lord, and the amount was given back to him. And thereafter, my lord, he started applying for the plot for 6 times, it has not been given. And another issue, my lord,
The lottery system, Mr. Gunjal.
the cash rate is not in as per statute. Those are the only 2 points.
Cancellation is a voluntary surrender.
Those are the only 2 points.
One nimisha, Mr. Kiran. You are better in the VC than here.
Those are the only 2 points. My appeal submission treated as like a mercy petition, some.
No, in two, Mr. Gunjal, look at the mercy that you are asking. 2002, you say. In 2002, you surrender a allotment because you are unable to pay. You have gone on applying, but not succeeded in the lottery system. That is 2002. We are in 2022 now.
Thereafter, he has made about 7 attempts, my lord, I have got the application.
Yes, can we? It's a lottery system. Lottery system, seniority. Seniority no bandil vayirge. Seniority no bandil vayirge.
Because once allotment is hard, clear attempt.
Well, now
again it will be a fresh proceeding.
He again went to 6 attempts. First attempt, second attempt, third attempt, getting.
When it came to you, best attempt ಆಗಿದೆ Mr. Kiran. After 2002 ಎಷ್ಟಾಗಿದೆ?
After 2002, you have not made an application. He is only making the representation.
He has made a 9/2018 one more application, Lord. Before that, he has made on 23/24.
Application, Mr. Gunjal.
Application, madam.
ಕೊಡಿ ಕಾಪೀಸ್ ಕೊಡಿ ನೋಡಿ ಅಲ್ಲ ಅವ್ರು ನೋಡಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಪ್ಲಿಕೇಶನ್. You give all the copies of the application to Mr. Kiran. Mr. Gunjal, you please give all the copies of the application to Mr. Kiran because you have not produced it yet. Shri V.V. Gunjal, the Red Council. After tomorrow, Indra. Shri V.V. Gunjal, the Red Council for the petitioner, submit that you would furnish the details of the application made by the petitioner for allotment of site to Mr. Kiran, who seeks for a week's time thereafter to obtain instruction, make a submission. Release on 2/8. Yes. Who is the impleading applicant? It's already allowed.
It's been allowed. And in fact, they filed their objections as well. So all meetings are also completed.
Yes.
But the short point that the register of consideration in this matter is a particular site, which was originally a part of a road, was converted to a site, released as a site by the BDA. Khata was issued, taxes were collected, building permit, construction was issued, all of them done. Subsequently, the neighbor filed a suit against the original owner of that site, saying that this is a road, it is not a site, and therefore declare that this is a road. That is a suit filed in the civil court. In the civil court, the BDA filed an affidavit stating that this has validly been released. It is no longer a road, it is a site, and therefore the site validity may be replicable. Unfortunately, the BDA does not modify the layout plan. In these circumstances, the civil court says that since there is no modified layout plan, I cannot recognize this as being a valid site. In these circumstances, we move the Honorable High Court seeking a direction against the BDA to modify the layout plan to say that this is a site. That petition is allowed, directing the BDA to consider my representation within a short period of time. The BDA considers it a little belatedly, but thereafter sends me a letter saying, I recognize that my officials released this site. However, that official has done an error, and therefore this is not a valid release of a site. We will take necessary action against the official. For now, we will not modify the layout plan. Thereafter, this petition came to be filed, wherein we are requesting the BDA to modify the layout plan or in the alternative release an alternative site in our favor. During the course of proceedings, this Honorable Court asks the BDA what action has been taken against the relevant officials who have allegedly done something in their shop. The BDA files an affidavit stating that these people are long retired, therefore I am unable to take any action against them also, and therefore it is for the petitioner to suffer. That, my lord, is the brief summary of the relevant facts that are an issue in this matter. The key documents, my lord.
When did they retire, Mr. Sachin? When did they retire? So stop their pension. Stop their pension.
The society itself recommends the BDA to allot the site number 1A.
The problem is, if the society has done it, we can always say that. But your officers have done it.
BDA released all the site members. They have produced the layout plan. As per the layout plan, there is no site number 1A. What happened was, as per Annex B, the society has released the site saying that about this site is what it's supposed.
Yes.
Without verifying the layout plan, we have allotted the site. But
How can you do that?
Based on this letter issued by the society, BDA has allotted the site. It's not about BDA released the site. Allotment has been made by the society. It is not finding a place in the group. It's a road. Mine is following the southwest column. Next to my site is not existing road. I placed this layout plan. The road has been converted aside, and the BDA official who has released it. Not the layout plan approved.
Yes.
Next, on page number 6 of my statement of petition. Next, layout plan.
Yes.
60 feet wide road is there.
That portion has been clarified on this side. That is more.
So that road which connects to the existing road is gone.
It is not, my lords. It is not connecting to it. I will take you, my lords, through the relevant photographs, the relevant revised master plan. All of it show that it's a dead end. There's nothing that it leads to.
Lords, it is going to connect to the medial layout.
But it's connecting road first stage, we have the second stage. That's the squeeze and road later.
Who appears for the society? Society has been served and not come. Society has been served.
Yeah, because VA is the site which is recommended by the society. By oversight or by negligence,
When you see 1A, your antenna should go up. When you see an alphabet next to a site number, you should know that that site is a problem.
I mean, just take my lords to 3 or 4 documents so that it was validly released. And in fact, there's no prejudice that's being caused. In fact, my primary contention now, my lords, to amend the layout plan for the reason that no one will be inconvenienced. But it's not like just
You are a subsequent purchaser from the prior purchaser. So you should have verified the documents to see whether the layout plan was there for that particular site number. Now you are asking for a modification, knowing fully well that it was not there. So the release could never have happened, even according to you.
No. If I can just take you to 2 or 3 documents to show, I did my due diligence, and as per the records available, that site was there. Now, if I may just take 2 or 3 documents.
Yes.
The first, now, just so that we have context as to what it is we're talking about, there's a memo we filed on 29th November 2019, my lord, which is the photographs of the relevant site. So we have some ideas what we're talking about.
Page number?
Now, this is a memo. Page number 2 of that memo dated 29th November 2019.
Yes.
In that, my lord can see page number 2 and 3. You'll see, my lord, that where there are those pillars that are coming up. That is the site. Next to it is site number 1. And you'll see the second photograph, my lord, you see the road. The road comes in, it turns to the right. So you see behind the site there is already houses constructed. To the right there is a house constructed, and to the left there was a compound wall that has since been demolished. And that to the other side of that compound wall is where the road continues. These are all photographs of that particular site now. Just to give us some background as to the site we're talking about. Now, one of the relevant documents that I request us to see. The first is in the petition, Annexure F, page number 35. This letter is to the Secretary, Micro Shamajivi Karnataka Graha Nirmana Sarkara Sangha. Release of sites in private layout in circuit number 2212, so and so forth. With reference to the above subject, the sites have been released as statement enclosed. One sec. You hereby required to submit the affidavit to remaining person immediately. The very next page, my lord, you see. The very next page is a schedule. It says serial number 1 R Vasudeva Murthy, site number 1A, dimension so and so. To the east, site number 1, west PP, first stage north, south road. So here we see, my lords, the exact site that is under consideration has been released by the BDA, signed by Assistant Executive Engineer of the BDA. This document is not disputed. Thereafter, Khata came to be issued, which is the very next page, page number 37. Type copies at page number 38. This again, Bengaluru Abhivrudhi Pradhikara, Bengaluru. Khata issued in respect of site number 1A. Then, my lord, the next page, page number 39. Page number 39, my lords. Annexure H. Construction license is also issued for the scheduled property by Bengaluru Abhivruddhi Pradhikaran. So BDA has released the site, issued a khata, and has issued permission to construct the building in that particular site over the course of 3 or 4 years. On the basis of these documents, the strength of these documents, having done that due diligence, we proceeded to purchase that particular site in annexure number G. I don't want to go into the CH because that is not dispute. Subsequently, in annexure A, page number 51, this again, taxes are being collected with respect to this particular property. That's annexure number A. And if you see page number 53, Nagarasabha Bommanahalli has also issued a khata.
On all the basis of that fraud which is committed in the beginning. Fraud vitiates everything, Mr.
No, I'm only submission. It's not fraud, and I take my laws according to say there's nothing preventing a conversion of a road.
Even according to you, the layout plan did not mention 1A. So if we accept your submission and pass orders in this, do you know the chaos which is going to be caused? Anybody will do anything and then it gets rectified. Fraud vitiates everything.
No, this is not fraud.
Fraud by the society. Fraud was committed by a society. Power was not available with the BDA. It is all collusion with the officers that this site has been released, which never existed.
No, my lord, if I'm making just one judgment in that case, my lord, where exactly the same fact situation, this honorable court has upheld the conversion of a road into a site.
Hey, if you apply.
We apply, my lord.
If you apply prior to that release,
no, my lord,
there is no
subsequent. I will take my note to that one judgment which talks about subsequent. Yes. It's in the memo of citation that has already been filed. Yes.
Yes.
The decision K. Prabhakar versus Bangalore Development Authority, page number 1 to 6. If my lords will kindly look at the second paragraph of that term. By this petition, the petitioner has sought the issuance of a writ of prohibition or writ of order in the nature of writ of prohibition, prohibiting respondent number 1 from according sanction for conversion of the road into a site existing in between site numbers 10 and 11 in the layout as recommended by the assistant executive engineer as per annexure C. The petitioner has further paid for issuance of writ of mandamus, directing respondent number 1 BDA to demolish any construction or civil work that may have been taken up in the disputed site number 10 by respondent number 3 and to retain site number 10 in its existing position as a road for the use of the petitioner as well as other persons in the locality. So this is the fact situation. Paragraph number 6, page 2. On behalf of the petitioner, it has been contended that the road lying in the scheme of the plan to the north of the plot allotted or sold to the petitioner has illegally been converted or changed into a residential site bearing number 10A, as there is no approval to the modification by the BDA. Then it comes into the petitioner contend that there is no provision to allow any modification in the scheme or approved by the authority concerned, and that there is no provision. Alteration of the land on the northern side to mark as road into residential site number 10 was illegal, valid, and without jurisdiction. Shri Subhas Adi further contended that the claimant who purchased this plot along with the right of user of the road and permission to convert the said road into site has been detrimental to his right of user of the road. It is submitted that the petitioner has got easementing right to using of the road and the modification of the road into residential layout and the effect of depriving the petitioner of the right of user of the land and road. Then it also contends that no conversion be permitted, and as such, conversion or modification of that land into residential site by which site number 10 has been an illegal act on part of the respondent 2, and it further acted illegally selling the same or allotting the same to respondent number 3. Then it comes to the petitioner, I mentioned it. That is not very necessary. The last line, as regards the merits of the case.
Paragraph 7, there was an application made by the society.
There was an application in this case also. So
where was the application? For modification.
Is in response to the application.
For modification of the plan, where is the application made prior to your release?
My lords, the society's letters we have not been able to access. My lord, we only have annexure F, which is at page number 35. This is the release of site. Permission was sought for releasing it as a site, much like in the case of this Prabhakar also, my lord, where they requested that that particular site be released. But just to emphasize in this case, not only at the time of allotment, when the subsequent suit was filed, the BDA in the written statement on affidavit in court, my lord, has said that it's a valid release of the site. About 10-12 years after the date of release.
Where is that?
That, my lords, if you may kindly look at the written statement filed by the BDA in the suit that is under challenge. Annexure M, page 72. A different set of officers, my lord, annexure number M, page 72. Para number 4. It is submitted that the suit schedule B properties, independent site bearing number 1A, formed out of the land reserved for development in the layout, formed by the fourth dependent. The said site was formed by the society and released the same by this dependent during 97 for allotment in favor of Sri Vasudeva Murthy, the first dependent. The possession certificate delivering possession of the site in favor of allotment has been issued by the fourth dependent society. Therefore, the B schedule property cannot be treated as a road in the layout. This, my lords, is in 2005. The BDA on oath makes this statement before the court also. So, consistently, the stance of the BDA from the very day subsequent to all of these, Khata issue not early for collecting tax at the time of which issuing construction permit in court when a suit is filed, is consistently that it is validly released. It is only now, close to 20 years, 22 years later, that they suddenly say that it is not validly released. And to that, they have provided a citation to say that whenever the BDA can take certain actions, if they don't take action of cancelling allocation, you cannot do it after 20 years. That is on record, it's a self-evident proposition, so I do not believe that. So the only submission we say, in fact, if you look at the master plan also, just to show that there is no prejudice caused, it does not amount to shrinkage of the open area that is available. There is no such violation. In fact, the revised master plan also.
1995 was the sale deed. Possession certificate is given. 96 possession certificate. Then thereafter you release it also. And there is no objection for sale of the site. All executed not by the same officer but by different people. And we would understand if it is by the same people.
Based on the election BDA has issued election.
So how many people, how many of your officers don't verify documents? How many of your officers will go on just signing any order? And who signed the written statement? 2005. Certifying that the release is proper. Who are you? Who are you? Who are you? Who are you? You purchased the same plot. So, but there is no road there. There is no road there. There is a house there.
I have filed a suit and it is gone in my favor. But I have sought for information by the they say the written statement will form in the result of future development area. But you know, they say the information that RFP comes adjoining the site of making of the plan. With the election of the what my day is communication
when did you buy?
When I have bought the property.
$1990.
Remember, they have issued saving more this year. Right.
So you're prior.
1990 saving. So the schedule was they show this site number 2, west side road, south by. Also issued that. And then 1990 almost the renewal of plan was very clear. Next to site the one site RFP comes here next to site number 85. Clearly mentioned.
No RFP.
Reserve for future development. That's the area reserved by the society for future development. In a written statement, they say that site number 1A is formed out of RFP.
Where are the original records, Mr. Where are the original records? All the correspondence as regards this. Have you seen them?
But also, based on the connection E itself, they have considered the matter. Based on the connection is the basis of this allotment.
No, but based on one officer, this one you put everybody into trouble. If they are also in trouble, he is also in trouble.
Society has proposed site number 1.
And both of them are subsequent purchasers.
Yes, society, without society method, this issue cannot be. Society has proposed site number 1 to release that.
There is one more information actually. They were not sold that property as a common plot plan. And in fact, the revised master plan that refers to this area, and then we produce this as a memo, shows that that plot, there is no road there.
It doesn't matter about, don't go to revised master plan of 2015. Your plan sanction doesn't have your plot.
No, very well, which is why subsequently the BTA had the power and it modified it.
So where is that application for modification? If you have to call for it, if we call for it and it is not there, it is not there.
No, but the release of the site. The release
Without a modification, there cannot be a release.
Release.
So that is the risk you will be taking now. If there is a modification, then release can happen. The counsel for respond number 1 is directed to produce the original records pertaining to the present matter. Yav karte ho? We list on 2.8. Mr. Kumar. The council. I rejoinder file. The counsel for the petitioner seeks for and is granted 2 weeks time to file this rejoinder. Rejoinder is finished by 29. Relist on 3rd. ಕೊಟ್ಟಿಲ್ವಾ ಇನ್ನು ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಾ? ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದ್ರೆ ತೋರಿಸಿ, ಇಲ್ಲಾದ್ರೆ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. Counsel for the petition. Counsel for the petition undertakes to furnish a copy of the petition along with annexures on counsel for respond number 3 by end of day tomorrow. 3 weeks time is granted to the respondent to file a statement of objection. Objection if any by 12th, relist on 16th.
Serial number 51, my lord.
Yes.
My counsel is engaged in another court hall. Can you please pass over or have it next day?
ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಅರ್ಕಾವತಿ ಪಾಸ್ ಓವರ್. Despite the order dated 14/6/2022, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Ready? You are correct. ಅದು ಬಿಡಿ, ಅದೆಲ್ಲ ಅದಕ್ಕೆ ಎಲ್ಲ ಟೈಮ್ ಕೊಡ್ತಾನೆ ಇದೀವಿ. 54 Shri Murugeshwar Reddy submit that he has received the copy of the petition today. He seeks for and is granted 3 weeks time to file a statement of objection. ಇವಾಗ ಎಲ್ಲ ಅವ್ರ ಮೇಲೆ ಪ್ರೆಷರ್ ಆಗ್ತಾ ಇದೆ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರ್ತಾ ಇದೆ. Objection is written by 19th, released on 23rd. Interim order earlier granted is extended to next day. Yes. File ಮಾಡಿದ್ದೀರಾ objection? Counsel for the petition seeks for and is granted 2 weeks time, released on 3/8. Sorry, 2/8. Yeah, 3 and 3 ಮಾಡಿದ್ದೀವಿ. Mr. Samir, ಏನಮ್ಮ ಬರ್ತಾ ಇದ್ದಾರೆ? ಇನ್ನ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. None appears for the petitioner today also, nor are the copies of the petition furnished. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution, released on 2/8. Rejoined. 57 Learned Counsel for the petition seeks for and is granted 2 weeks time to file his rejoinder to the statement of objection. Rejoinder, if any, by 29th, released on 2/8.
My lords, I appear for the petitioner, my lords.
Yes, Mr. Gilbert.
My lords, my mother is an allottee of a site from the BDA, my lords. The erstwhile.
Ready, Mr. Krishna? Yes, ready.
Lords, my mother gifted the property in my favor, my lords. That is a petitioner herein. My lords, they issued an endorsement requesting for certain documents before this honorable court. My lords, they admitted that I am the owner of the property and that there is a gifted executive in favor. Lords, then thereafter, my lords, I provided. They said there are only 2 documents which are required to be provided, and if those documents are provided, this is in my favor. My lords, annexure S at page 82. My lords, may I request this court to kindly look into.
Annexure S at page
82, my lords.
Yes.
My lords, the orders passed by this honorable court at page 83. Counsel for the petitioner submits that the petitioner complies with the requirements of the BDA as indicated in paragraph 5 of the statement of objections relating to furnishing documents, including the EC from 5/6/2008, from the up to the date of representation for the purpose of consideration of request of executing the sale deed, conveying the site allotted to the petitioner's mother. It is needless to state that if the petitioner were to furnish his documents with a fortnight from today, there is no reason to believe that the respondent BDA would not consider the same and pass orders.
Yes, they have to consider.
My lords, I have provided the documents, my lords. The remaining exhibits are there. Now, my lords, they issue an endorsement. My lords, the property is allotted to my mother. They issue an endorsement, my lords, annexure W at page 125. My lords, luckily my mother is now, my lords, 90 years. She's still alive. They want the legal representatives of my mother to go in person and give a statement that they have no objection. So woman's properties are absolute property. Lords, my gift
Why
deed is
do you want that much?
2008. My client is 75 years. His mother is, my lords, 90 years of age. And now Annexure W, my lords, the endorsement issued. They want now a fresh encumbrance certificate from 1/4/1960. Then they want the original lease deed executed by CITB, my lords. It is somewhere in the year 1960. We do not have that. Last serial number 3. They want the remaining legal representatives of Devaki Ammal to come and give a statement in person before the Deputy Secretary 4. My lord, she is still alive. An LR can come only in the event of demise. My lord, this was for consideration otherwise. My client refused to, my lords, accommodate them. Then they issued this endorsement again, forcing me to come to this court.
Yes.
If their statement of objections in the previous writ petition is looked into at Annexure Raj, page 73, everything that now they want, my lords, they have said yes. My lords, I have surrendered my original gift deed executed by my mother in my favor. They have collected it. They had, my lords, were ready to execute the sale deed, at which time, my lords, they came up with this endorsement. My lords,
Not one encumbrance certificate.
my lords, I am willing to give the encumbrance certificate, my lords. The original lease deed, original
Lease deed of
allotment.
CITB is there. 3 is redundant.
My lords, 3 is redundant, she is alive, and CITB original document is not available, my lords. They have admitted she is, my mother is the allottee. They have taken the statement
Everything is
of
done.
the petitioner. They have taken the statement of Devaki Ammal.
Let us see what Mr. Krishna, hear what Mr. Krishna said.
Small scale industry, ನಮಗೆ ಸಂಪ್ರದಾಯ ಸರಿ ವರ್ಗಾವಣೆ ಮಾಡಿ ಸುತ್ತಪ್ರಾಯ ಈ ಸಂಬಂಧ ಮಾನ್ಯ ಆದೇಶ ನೀಡುವ 3 ಡಾಕ್ಯುಮೆಂಟ್ ಕೇಳಿದ ಒಂದು ಇಷ್ಟೇ mortgage there is any transaction to third party to private bank. Second, it is compulsory they have to list the sale agreement as to
You already admitted that in the earlier proceedings. Lease cum sale, our allotee anta, our lost anta idaralla. Again, mortgage create madenu our against hoguttalla, Mr. Krishna. It's not a property being transferred to you. It's a property, nimge liability baratte. That will clarify.
My lords, may I request this court to
The property continues to be in their name. It's not being transferred to you. If it is being you purchaser andre, we agree.
My lords, sale.
Just a moment, Mr. Girdhar.
Sorry.
If there is a allotment is not dispute. Your only contention is if there is some encumbrance created. For that, they will give you indemnity. And we will make an observation. Encumbrance certificate ಕೊಡ್ತಾರಂತೆ. ಅದು also takes care of your issue. ಇನ್ನೇನು ಉಳಿದಿದೆ ಇದು ಎಷ್ಟು ವರ್ಷದಿಂದ ಪಾಪ ಅವ್ರು ಇರಬೇಕು. 2014 ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ, ಅದರಿಂದ ಆಗಿದೆ, ಎಷ್ಟು ಅಂತ. From 2008 it has been pending for this. 14 ವರ್ಷ people are not able to use their property andre, who is going to pay the damages for that? If the property is 14 years back, if you had executed the sale deed, they could have sold it, they could have done something with it. 14 years they have lost the right to use the property. Except the possessory right, ಬೇರೆ ಯಾವ right use ಮಾಡಂಗಿಲ್ಲ ನೀವು ಮಾಡೋರು. Not fair for the BDA to do this. I was asking a 97-year-old lady to come to your office.
ಉಳಿದ ಮೆಂಬರ್ಸ್ ಇಂದ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂತಿಗೆ ನಾನು ಉಳಿದ ವಾರಸುದಾರರು not the 8 years
ಪಂಚಕೇದಾರರು ಉಳಿದ ವಾರಸುದಾರರು ಖುದ್ದಾಗಿ ಏನಕ್ಕೆ ಬರಬೇಕು? ಅಫಿಡವಿಟ್ ಕೊಟ್ಟರೆ ಆಗಲ್ಲ. Give affidavit, Mr. It is not for your grandmother, Allah. The grandmother, they don't want to come.
My lords, a legal heir will come only on the demise of the owner. She's gifted it to the son. They want the other children to come. How is there a legal
ವಾರಸುದಾರ ಬದಲು other children ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ, but
they have no objection.
Be a death, my lords. We do not know, my lords, the other children
who will predecease, whatever, we don't want to get into that. But the other children can give it.
No, my lords.
Now you are also splitting hairs. If you want to be splitting hairs like this, you will wait for another 20 years.
I am only submitting, my lords, if the requirement of that either under the BD Act, if there is something which authorizes them to do this. If they want
you approached after 1960, Mr. Girdhar, so you also have to be reasonable.
My lords, my mother has personally appeared and given her statement. It is recorded. They have taken the statement from Srimati Devaki Ammal to the effect that this property is gifted to her son. The previous writ petition, they filed their statement of objections telling everything is done. Yes, there is a transfer. Yes, he has become the owner, but this encumbrance certificate is not given. You give me that. May I request this court to kindly see the statement of objections filed, my lords, in the previous.
You still haven't given the encumbrance certificate.
They have asked for a different period now, from 1/4/1960. My lords, page number 75, my lords.
Your encumbrance certificate would have been from the date of allotment, not from the date of your gift.
Please, my lords, but in the previous statement of objections, which was filed, challenging the previous.
If these are the submission made, then what Mr. Krishna says appears to be something fishy about this.
My lords, there is nothing fishy about it, my lords. They want
furnish those documents.
My lords, as I submitted, my lords, document number 1 giving an encumbrance certificate can be furnished. Document number 2, sale agreement, it is misplaced. It is a registered document in the office of.
So give a police complaint and give a copy of the complaint.
Insofar as document number 3 is concerned, my lord, so that document cannot be provided and they are not entitled. The lady is alive, my lords. Where is the question of an LR coming in?
Then wait, we can't help you.
All right.
We'll list on. It is for the respondent petitioner to provide the documents which have been sought for by the respondent. If interested, relist on 16(8). Yes, suit ಹಾಕಿದ್ದೀರಾ? Yes, Mr. Krishna, there is no suit. So, suit number ಏನಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ? ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ನೀವು ಹೇಳಿದಿರಲ್ಲ, ವಿ ಅಲ್ಲ, petitioner came to know that the landlord has filed a suit. A suit number ಅಂತ ಹಾಕಿಲ್ಲ ಅಂತ. Mr. Vasant Kumar, it's not whether you have filed the suit. ನಿಮ್ದು ಕೇಳ್ತಾ ಇಲ್ಲ. ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ನೀವು ಹೇಳಿ landlord has filed. ಸೂಟ್ ನಂಬರ್ ಕೊಟ್ರೆ ಅವ್ರು ರೆಕಾರ್ಡ್ಸ್ ತೆಗಿತಾರೆ. If you don't come and help them by giving the documents, how will they pass orders? How can we pass orders in your favor?
There is no access to this part. And we made representation, the landlord has a lorry fence. There is no access to.
ಇವಾಗ ಸೂಟ್ ಇದೆಯೋ ಇಲ್ವೋ ನೀವು ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಅವ್ರು ಫೈಲ್ ಮಾಡಿದಾರಾ?
ಅವ್ರು ಮಾಡಿಲ್ಲ, ಅವ್ರು ಲ್ಯಾಂಡ್ಲಾರ್ಡ್ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಲ್ಯಾಂಡ್ಲಾರ್ಡ್ ಹತ್ರ ವೆರಿಫೈ ಮಾಡಿ ಕೊಡಿ ಡೀಟೇಲ್ಸ್. ಕೊಡಕ್ಕೆ ಏನಂತ ಪ್ರಾಬ್ಲಮ್?
But he said only has said that
they will make the, if you record your statement that landlord has not filed and they find some suit, it will be a problem.
If he just filed the suit against me, I would have issued the court notice.
Vasant Kumar, the counsel for the petitioner, submits that the petitioner has not filed a suit, nor has the landlord of the petitioner filed the suit, and the statement made in para 4 is what? Is a false statement again. ನೀವೇ ಹೇಳಿದಿರಪ್ಪ, when the petitioner went to the spot and came to know that the landlord has filed a suit and fenced the above site. And it is because of the landlord that there is no access. And you all know that you suit illa antira. And the statement made in para 4 is on the basis of the information received by the petitioner from the landlord. And the petitioner have not received any notice in the matter. Nimge ಏನಾದ್ರು notice ಬಂದಿದೆ Mr. Krishna? ಅಲ್ಲ, ಈ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಏನಾದ್ರು BDA ಪಾರ್ಟಿ ಮಾಡಿದಾರ? ಅದು ಮಾಡಲೇಬೇಕು. Petitioner is before this court seeking for the following views. The contention of the petitioner is that the petitioner is that one KP Anjanappa was the owner of the land in survey number 39/4, for which he was allotted the incentive site number 503 under the 4060 scheme. The said Anjanappa has sold the said site in favor of Sri Basvarajappa on 26/2018, and the said Basvarajappa executed sale in favor of the petitioner on 6/12/2019. When he went to the spot, he was informed that the former landlord had filed a suit and fenced the site, and as such a representation was given to the respondent on 14/2/2020, requesting the executive engineer North Zone to remove the fence and provide access to the petitioner. The petitioner also submitted one more representation on 8/7/2020, which has also not been considered by the respondent. As such, the above reliefs have been sought for. Correct. ಇದು ಮೂರನೇ ಇದು ಲೈನ್ ಹೋದ್ಮೇಲೆ ನೀವು ಹಿಂಗೆ ಕೋರ್ಟ್ಗೆ ಬರ್ತೀರಾ, ಅವ್ರ ಅಗೇನ್ಸ್ಟ್ ಹೋಗ್ಬೇಕು ನೀವು. You have to reject this, Mr. Vasant. You can't do this. When you have made a statement that your owner has fenced it, it's a civil dispute. Why should you involve BDA in that? No. The grievance of the petitioner from a reading of para 4 is that the former landlord has fenced the property. If that be so, I am of the considered opinion that same is a civil dispute between the petitioner and the previous landlord, and the BDA cannot be directed to remove the fence by considering Annexure L being a representation submitted by the petitioner. If at all the petitioner has any grievance against the former landlord, it is for the petitioner to take such action as may be necessary in accordance with law. Petition stands disposed. Dismissed. Ready now? We'll come back. We'll come back. We'll come back. We'll come back, Mr. Kiran. Which month? 55 interim order is extended next week. 97 objections there. 97 it is submitted. The counsel for the petitioner is not well. Objections if not filed to be filed within 2 weeks from today. Released on 16/8. 27. Huh? 27.2 disconnect and released on 3/8. 63 was copy banta. 63 Leonard counsel for respond number 2 to 4 submit that he has received the copy today and he seeks for 2 weeks time to obtain instruction and make a submission. Mandamus submission with a mandamus a problem. We released on 3/8.
Ma'am. Bench officer, ma'am. ಹೇಳಿ ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ ಮ್ಯಾಮ್? ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 52.
52 ಡಿಸ್ಮಿಸ್ ಅದು
ಮೇಡಮ್.
ಡಿಸ್ಮಿಸ್.
52 ಡಿಸ್ಮಿಸ್
ಮೇಡಮ್.
ಹೇಳಿ ಸರ್.
ಕೋಟಾ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 53.
53 16/8 ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
16/8.
ಹೌದು 16/8.
ಓಕೆ ಓಕೆ ಥ್ಯಾಂಕ್ ಯು. ये पूरा मिलके एक डॉक्यूमेंट है ना, एक पार्टी का। देखा पड़ेगा। देख अलग अलग करना है क्या इसको? किसका? नहीं हम तो डॉक्यूमेंट मारते हैं, जैसे पेज नंबर डालते हैं ना, ये सब मिलके ये तीनों पेज एक ही का है क्या? ये तीनों पेज ये तीनों तो एक का है, लेकिन बीच में उसका और भी आप ऐसा कीजिए। करेक्ट, यू आर राइट। एक एक पार्टी का एक एक वो बनाना पड़ेगा, क्योंकि एक उसका एक बनाना पड़ेगा, दूसरे का दूसरा बनाना पड़ेगा। बहुत बढ़िया। वो अलग नहीं तो कंफ्यूजन मेरे को कंफ्यूजन है, इसको थोड़ा कंफ्यूजन तो निकाल के रखो। ये बेटर ऐसा कि ये इसमें क्या बनाना है। मुझे पता है ना इसके बारे में। हाँ करेक्ट करेक्ट। इसलिए मैंने क्यों आने के लिए बताया कि ये हमारे को मेल बता सकते हैं, बट ये है डेविड कोड और इसका है एक पार्टी का एक ही सेट में रखेंगे। No, I get it. इधर रहते हैं।
अभी
हाँ
कुछ मार्क करना है, इसके ऊपर लिख दें क्या? RN इंडस्ट्रीज का ये
नहीं करेंगे। RN की जगह
RN तो इसका ईमेल आईडी ये लिखा हुआ।
अच्छा RN इंडस्ट्रीज
इंडिया प्राइवेट लिमिटेड।
ओके।
अब इसके अंदर सारा है, क्योंकि ये इसका पीओ है जो उसने दिया है, और इसका पीओ है, इसका पीओ है। ये लास्ट में देखिए इसने ये बोला हुआ है, ये हमने उसको डाला है इतना पेंडिंग है, पेमेंट नहीं मिल रहा है।
उसका रिप्लाई क्या है?
उसका रिप्लाई नहीं है ना, क्योंकि उसकी पेमेंट उसकी प्रॉब्लम आ रही थी कुछ। देखिए टेस्ट सर्टिफिकेट का है, पेमेंट दिया है, और उसके बाद
नहीं अगर हमने कटेस्ट करें वो उन्होंने काम से नहीं सही किया।
नहीं, जो ये एक्चुअली जो RNPL है, जो ये है, ये थर्ड पार्टी है जिसको हमने सप्लाई किया LT के थ्रू। LT ने हमें, ये LT का क्लाइंट है, उन्होंने हमें बोला ये तुम इसको ऑर्डर ले लो और उसको सप्लाई कर दो। तो ये क्लाइंट एक्चुअली उसका है, कुछ प्रॉब्लम आ रहा था LED फिटिंग्स में, ये नॉट वर्किंग हो रही, इसलिए इसने हमारी पेमेंट रोक लिया।
अच्छा ये आई वांट दिस।
हाँ, और फिर उसका जो मैनेजर है सुदेश गुप्ता, जनरल मैनेजर, उन्होंने उसको रिप्लाई भी किया है कि आप इतना पेमेंट हमारा है जो सेशनल एंटरप्राइजेस का है वो रिलीज कर दो, हम आपका वो काम करवा रहे हैं।
In the meantime, you are requested to please the wrong pending person. This amount is pending since May last year.
लास्ट ईयर मतलब तब से, मतलब 17 से, ये 18 है ना ये, तो 17 से, और ये इनका क्लाइंट है कोको कोला का। तो ये LT का क्लाइंट था जो हमारे थ्रू इन्होंने रूट करा कि हम चैनल पार्टनर हैं। तो क्लाइंट तो उनका है, तो पेमेंट अगर वो प्रॉब्लम आ रही है उसमें फिटिंग्स में और वो नहीं दे रहा, तो फिर वो तो वही वो कराएंगे ना। उसको इसलिए लाइट फिटिंग में प्रॉब्लम थी, मैन्युफैक्चरिंग डिफेक्ट था, जिसकी वजह से हमारी पेमेंट रोक गई।
Yes sir. This is
ये एक कंपनी का होगा, ठीक है, इसका एक प्रॉब्लम का वो पूरा होगा। अब ये जो है ये आपका मार्टिनेट का, ये वाली जो इशू है, ये वाली मार्टिनेट कंपनी का है, मैं डाला हुआ उसमें। इसमें इशू ऐसा है,
बताइए।
इसमें से देखिए, इसने जो पीओ दिया है ना, ये डायरेक्ट उसने कंपनी को दिया है, ये लाइटिंग टेक्नोलॉजी को दिया है। डायरेक्ट पीओ LT कंपनी को दिया है मार्टिनेट ने, ये कंपनी का क्लाइंट है उनका, जो हमारी हाँ
application.
separate ಮಾಡಿರ್ತಾರೆ ಯಾವುದು ಎಕ್ಸ್ಟ್ರಾ ಇದೆಲ್ಲ
I for rejection of print ಅಥವಾ ಒಂದು ನಾವು ಇದು ಈ ಕಾಪಿ क्यों है डॉक्यूमेंट अच्छा हो गया एक है ये ईमेल है ना हाँ सारा ईमेल है सर
ये पीओ लिखी थी ईमेल के थ्रू ही आया
ये नहीं है ना
हाँ परचेज ऑर्डर है ये आगे भी पीओ
ये क्या है कौन सा पीओ
ये परचेज ऑर्डर है
ये पीओ क्या
हाँ जी
पीओ पीओ ये पीओ ना
ये तो मेल है वैसे लेकिन है पीओ ये परचेज मेल के थ्रू आया है सारा पीओ
ठीक है
ये मेल की कॉपी है ना कि उसने हमें बोला है कि ये भेजने के लिए क्योंकि राकेश मिश्रा जो उसका मैनेजर है उसने बोला कि ये आप डिलीवर करो
किधर लेना लिखा है
ये पीओ जो पीओ आया है ना कंपनी को ये इन्होंने एलटी को पीओ दिया इस कंपनी ने इसने हमारे थ्रू करवाया है और लास्ट का जो है इन्होंने किसी और से
ये लेटर में क्या लिखा है
इसी का कॉपी है ना ये ये इसने ये भेजा है अटैचमेंट भेजा है इसके साथ ये लिखा है फाइंड अटैचमेंट मतलब पीओ भेजा है
ये एक ही डॉक्यूमेंट है
हाँ ये भी वही परचेज ऑर्डर लिए
यस और कौन सा डॉक्यूमेंट
इसका स्टेटमेंट लगाना है आरएन वाला पेंडिंग है
आरएन वाला हाँ
स्टेटमेंट है
यस सर
इसका आरएन का है
सब पे डालेंगे हाँ स्टेटमेंट ये क्या है इसका आरएन का
ये स्टेटमेंट है हाँ स्टेटमेंट भी दिया था आरएन का
स्टेटमेंट ये क्या है
ये सर ये इतना हमारा पेंडिंग हो स्टेटमेंट पूरा लीजिए
आरएन
इंडस्ट्री ये जो आपने रखा ना
हाँ हाँ
ये इसी का है इसलिए ये हमने बनाया कि ये इतना हमारा पेंडिंग है
अच्छा ओके
क्लोजिंग बैलेंस होता है
अच्छा So we continuation ये भी.
हाँ, ये इसका continuation बिल्कुल.
Okay. Okay now.
Next is debit note.
ನಾವೆಲ್ಲಿ ಫೈನಲ್ ಹುಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಣ ಇವರು ಆರ್ಡರ್ ಶೀಟ್ ಕಳಿಸ್ತಾರೆ.
Hmm? 52. You have not been appearing for so many dates. 5-6 dates you have not appeared. Sorry, 5 crores. That's it. Pass over and will regard it as pass over. Hmm. They filed an amendment application. Only including application senior. Hmm.
That last petition, the matter was moved again. So that's the directive we created to produce the and ultimately demarcation. Then we were, in fact, afterwards we counsel for the amendment and voice withdraw the petition and file a letter. And certify the last petition of the matter was approved again. So they have to file it. Now at this stage, they filed an amendment application. So last petition, we file the application, but we take the amendment. And PDF to I have got it. On the last occasion, we were not certain the matter. For the petitioner, I have his same endorsement dated 8/7/2022 of produced. If I may use this greatest property phrase, that endorsement is taking everybody including the court right. Therefore, I have filed the IA for amendment. Questioning that endorsement of
Anyway, IA for amendment is not listed, is what we are trying to say. Baniri. 115. It is submitted that the counsel for the petitioner has filed an amendment application The counsels for the respondents seek for and are granted a week's time to file their respective objections to the proposed respondents and the proposed respondents to file their objections to the said application. Objections, if any, by ಯಾವ file ಮಾಡ್ತೀರಾ? By 25th, released on 26th. Tuesdays are BDA matters. Writ petitions allowed. It is declared that the scheme Bairasana Tavarekere Madiwala layout BTM 6 stage propounded by BDA as approved by state has lapsed insofar as land of the petition is 7 number 80/1 situated Ulima so between 2 acres 4 guntha. Possession of the property not having been taken, section 36 of the BDA Act is declared inapplicable to the lands of the petitioner. Consequently, the preliminary notification bearing so and so, final notification bearing so and so are quashed. Consequently, a certiorari is issued. The resolution dated 24/4/2008 passed by respondent. Also, letter of allotment of civic community site dated 19/5/2008 issued by respondent number 2 as per annexure U1 are quashed. Writ petitions allowed in WP number so and so. All the awards and reminders are quashed. The competent authority is directed to comply with the requirement of subsection 1, 2, and 3 of section 3G of the National Highways Act 1956 and determine the compensation entitlement of the petitioner by applying schedule 1, 2, and 3 of the right to fair compensation and transparency in land acquisition so act within a period of 4 months from the date of receipt of a copy of this order and thereafter issue necessary award notices. In the event of the petition is not acceptable to the compensation determined by the competent authority and the award notice is issued in terms of direction 2 above, the petitioner would always have the liberty to approach the arbitrator appointed by Central Government in terms of section 3G5. What we have held is that the schedules are applicable. By the competent authority has to do it first. You cannot push it to the arbitrator. First, let the competent authority do it. Then he has to follow the process of PG 1, 2, 3. Notify it, invite objections, all those things have to happen. Then if they are agreed, 3G5. You cannot not do it and say go to 3G5. Yes.
They don't ask to be considered as an activity bank order. That is what
the duty is on you, is what we have held. Duty is not on them to come. You can't expect a land user to come and do whatever. You know what is happening. You have to do it.
Hello.
During the pendency of the above matter, who expired? Sole petitioner. The sole petitioner expired on 17/8/2020. Hence, IA 1 to 3 of 2021 have been filed on 24/3/2021 for condemnation of delay, setting aside abatement and bringing the legal opinion of deceased petitioner on record. Correct. Accepting the reasons stated in support of IA 1 of 2021, the delay of Yesterday delay.
41 days.
Delay of 41 days is condoned. Consequently, by allowing IA2, abatement is set aside. By allowing IA3 of 2021, the persons named therein are brought on record as brought on record as 1A to 1D. Counsel for the petitioner to carry out the amendment and file amended fast title within 2 weeks from today. Mr. Ramakrishna, you are appearing? You filed your objections? Yalla agidya. Pleadings being complete. Was the matter for final hearing on 16/8. Yes, Mr. Kalyan, what happened? Hmm. You have to file an affidavit and copy ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ. You produce the memo that you filed? You produce this memo of 8/12/2021. So where is that memo copy, Mr. Yeah. 8/12/21 memo. Where's the memo? I will produce this now. You produce a sub-registrar's valuation slip. What you are saying in your affidavit is that the presiding officer asked you to produce a document.
Valuation of the publisher's value.
We will recall the order and hear the matter, Mr. But the effect is the same.
And we have not made any other memo, other than this memo, filed along with the company. We have not filed any other.
You undertook to cooperate.
Even now, I am bound by the
Please hear us out. You undertook to cooperate. 1910 it was posted, you took time. 2011 it was posted, you took time. 8/12 it was posted, you took time. 12/12, 21/12 you filed this. 4 months. Is that the cooperation, Mr. Kalyan? Yes, we are reading from there on. What did you do on 1910?
1910 lots of there was no proceeding.
On 1910.
1910, there was no proceeding.
On 15/9, what did you do? First, we'll have to come to 15/9. On 27/9. So it won't apply. So 1910 was declared holiday. So on 2011, what did you do?
I was supposed to appear before 2011. 2011, we got taken assignment on lead evidence.
Yes.
2011, it was 8/12.
Where you filed this memo?
We got 8/12,
We'll hear the matter on merits.
there was no intention to not fight the petitioner. It was at the instance of the court, board on direction, this was filed.
Yes, no problem. Let that be. We will not attribute any intention if you are saying so. We'll take the matter.
As per the direction, directly 1 year. The respondent said, will not keep any adjournment before the trial.
Why should not we take up the matter and dispose of the matter? It was not disposed on merits.
It was disposed on merits, but subsequently, at the request of the opposing party, that the matter should be disposed early within a time frame of 1 year.
Now there is somebody who has expired. Will you appear? Who will appear for them?
That is not dependent on the right of the.
So it will take its own sweet time.
But now we got dispose the matter, again we got regarding. No, it was not on the part of the intention of the plaintiff.
But the effect is that, Mr. Kalyan, we will not attribute any malafide, though we could. So we'll just recall it, take it up and dispose of it.
Not only affidavit, I have filed it, but I have not stated anything that but then what the transpired before the trial was.
We don't find it to be cooperation. As undertaken. ಇರ್ಬೋದು ಅದಕ್ಕೆ ಬಂದಿರೋದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಅಂತಾನೆ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಬರ್ತಾ ಇರಲಿಲ್ಲ. That 1 year is already up in 1 month. After
2 months. We will not seek any adjournment. Even
in that 10 months, not even one pin has moved. And you want everything to be done in 2 months because of what you did? Sorry. Application. Affidavit and valuation slip has been filed. The same is taken on record. Not necessary, Mr. Kalyan. This is between us and them. Yes, so why are you shirking away from the matter being heard? This gives more information that you want to delay the matter. Now the malafidis will come in if you are going to be objective. Then let it be taken up. What's the problem?
There is an observation made by this honorable court by disposing of the petition. Because the earlier suit filed, it is suffered by the other party. It was confirmed with the RA.
We are not on those matters. We are on what happened after the order.
It was not the intention.
If you want us to make observation, we'll make an observation. You could have filed it by now.
Because the dispose of matter, the party had taken back entire file, subsequent asked to the file.
If you are,
some artists passed again without my objection.
Sri Kalyan seeks for and is granted. A week's time, released on Monday. 22nd, Monday, 25th. Vanaja. She said she is not well. None appears for the respondent, though called twice, released on 26/7.
I represent the petition in this case, madam.
Have you filed the affidavit, Mr. Hemant?
I have filed it on 15th June 2022, Lordships. It is before Lordships. 15th June
filed on
2022.
15 June.
Yes, Lordships. I have filed an amended petition along with I have filed this affidavit also. Page number 14.
You filed the affidavit along with the amended petition.
No. Amended petition also I have filed. Separately, I have filed an affidavit also, but it's the same compilation.
Amended petition jate.
The same compilation.
You have not received the amended petition also. You have not served it on Mr. Vachan?
I have mailed him, Lordships. I have requested him. I have mailed him. I have mailed him. I have taken his permission to mail him. I have mailed him and I just filed it. My annexure is at page number 14, Lord. I mean, the affidavit.
The petitioners are not wanted to complete the case.
Now they have issued an endorsement stating that.
You serve this one. Mr. Hemant, there are some documents from KSFC which go against your affidavit.
My lord, sir.
KSFC letter.
My lord's case. Now what has happened, your lordship? Annexure J may currently be produced, lords. Annexure J, the endorsement which they have given now. They say that we have to obtain NOC from KSFC. My lords, KSFC has nothing to do with this, lordship, because the property which the petition says mortgage.
Since you are not here, Mr. Vachan has filed a memo enclosing some documents issued by KSFC to BDA, saying that the property is mortgaged.
All right, my lord. I'll just take the document and then I'll just submit.
Client they will get into trouble.
I'll just take those documents and then I'll seek instructions. I'll come back to you.
Sure. KSFC Madilwa. We'll implead KSFC.
All right, lordships. I will do.
B. Vachan has entered appearance for respondent number 1 and 2. Registry is direct to delete the name of MD Prabhakar as that appearing for respondent number 1 and 2. The dispute in the above matter relates to certain transactions said to have been entered into by the petitioner with Karnataka State Financial Corporation. The petitioner claiming that no such transactions are there and no mortgage in favor of KSFC, while the Bangalore Development Authority contending that it has received documents, it has received correspondence from KSFC that the property has been mortgaged. In view of the above, I am of the considered opinion that Karnataka State Financial Corporation is required to be implemented as a party respondent in the present proceedings. Shri Hemant Kumar and Shri B. Vachan and councils don't have any objection. So also concur with the same. In view thereof, the KSFC is brought on record as party respondent number 3. They are a standing council. Shri Bipin Hegde is directed to accept notice for respondent number 3. Counsel for the petitioner to furnish copy of the petition along with annexures on Shri Bipin Hegde. Shri Vachan to furnish copy of the memo along with documents on Mr. Bipin Hegde. Released on.
Now the case is one submission, Lordship.
Yes.
Now KSFC has instituted a proceedings under Surface Act, Lordship, with respect to the other property which has been mortgaged, not with respect to this property. This is my submission,
No. Band earlier.
I will.
Released on 2/8.
Okay.
Mr. Deepak.
I appear for the petitioner, my lords.
Yes.
My lords, the site in Arkavati.
This will have to go to the committee, Mr. Deepak.
My lords, an instance where from 2007 I was fighting, my lords. And here is a case where a lease cum sale deed was also executed and entire.
And there is a order of the coordinate bench, it has to go before the. So please don't make those kind of submissions. Petitioner is before this court seeking for the following relief. The coordinate bench of this court in WT number so and so has constituted a committee to look into the grievances of the site owners in the Arkavati layout. In view thereof, I am of the considered opinion that said judgment is equally applied to the case of the petitioner, and the matter and the issue raised would have to be examined by the committee. As such, I pass the following order. The petitioner is permitted to file a representation with the committee within a period of 4 weeks from today.
Please.
The committee is requested to consider the said representation at the earliest. Yes, madam. That's right. Ready? 52. Why, madam, you are not appearing in this matter at all? From the filing, you are not appearing. Ready?
Please. Ready.
Ready.
And I have got a borewell dug in that land, my lords, and post that I've been in possession of that land for 2 decades. Recently, my lords, the respondents had come and disconnected the water supply. However, by virtue of the order passed by this honorable court, it has been restored. Therefore, they have filed an objection that virtually my prayer has been answered. The third prayer was pertaining to the restoration of water supply. However, my lords, my second prayer is honorable court may declare the action as illegal.
We are filing a civil suit here. And pass this out. Then you withdraw this petition. Otherwise, we'll have to make observation. May not. That counsel for the petitioner submit that the petition may be dismissed as withdrawn on account of the petition having been rendered infructuous. Accepting the said submission, the petition is dismissed as withdrawn. Sharad Gowda. Mr. Unnikrishnan. Ready, Mr. Bhatt? So, ಬರ್ತಾರೆ. 117 at the request of counsel for the petitioner released on 2/8 second. 116. 116. And 16 at the request of the counsel for the petitioner released on 2/8. 116 no. Ready na?
I am for 118.
You are for 118. So Charity 116. Aditya, you are ready in 116 and you want time in 118. Now, if you are ready in 118, we will take 116. You can't pick and choose. Yes, Mr. Reddy. So that means the RTI endorsement is correct. So if that is correct, then yes. Rejoinder amendment. Yes. No, Minister, rejoinder is ready. So all the details that you have put in your rejoinder is from here.
Yes, sir. And media also find interpreters assigning the user their division with the director dimension population authority and the section 48 seeking for deletion of plan. Now, in this statement, page 5, page 20, very same notification, the exchange was notified as per the preliminary notification, final notification, and ultimately, this court has not only
and your land also continues to be in your possession, therefore it is lapsed. Yes. 12%. Yeah, we have read the entire.
Subsequent to the decision in the connection, yes. We approach this court. We have not immediate to the attention that they already utilized land by allotting this.
Yes. This was by the allottee. This petition was filed by the allottee. And the finding that you are reading is as regards the allottee. What is the finding as regards the landowner? And that is only to protect. Finding is.
Ultimately, at Karnataka, constitutional petitions are allowed. The contention sought to be raised by the Commission for BDA is not very consideration.
Yes. But the
stating that we are giving an alternate right to all the allotted in this survey. This will not be relevant for the present case.
There are no allottees here before us, so that is not something.
In this very particular case, present
No, in what Mr. Gowda is reading.
In 53124, but in this case, there were allotments which were made.
Yes.
But they were not given a possession of the property. But the matter had earlier gone up to Supreme Court, under the Supreme Court. There was a second round of litigation initiated when another person came into the owner of the property. When the first litigation had reached under the Supreme Court. That point of time, BDA had filed an affidavit stating that we are giving alternate right to all the allottees and no allottees.
What Mr. Gowda is only trying to say is in two other matters earlier, this has been considered and held to be lapsed. Anticipation, Amal Bunny. In argument, anticipation.
In the present case, also there are allottees, so cancel those allotments and let them claim it from BDA. That is what is happening.
We will come to you, Mr. Chaudhary.
Therefore, when another landowner the BDA came up with the condition, they try to distinguish the BDA and they get there are allotments of findings of this particular portion of land is concerned. Therefore, the decision is part of it. The earlier single case did not accept the argument of the BDA, and then even if there are allotments, it is for the allotments to take appropriate action with the BDA, the land stands flat. Scheme is not substantially important. Because as against this matter, the BDA applies to the connection.
Connection?
And one of that is a page 47, and the 49, the one who is that is interpreted as therefore, the government figure understand as a statement of objection. The survey number 32 was totally consists of 5 acres and 8 acres of land. Out of this 5 acres and 8 acres, admittedly 2 acres is denotified in favor of single excess cooperative society. So they say no matter in parity, 2 acres of land was acquired by the authority for formation of further extension of RME notifications. It is further certificated that award has been filed with respect to survey number 50, 5 acres, 8 acres in LAC number 33/82/80 and award of rupees crore for possession has been taken. This is the categorical standard. No matter after this, I made series of applications under the Relation Information Act to verify whether such an award has been passed. There is no such award. Rather, all that I was provided is a register extract.
Where there is a mention of deposit, which is also not there.
It is also not. There they mentioned that it is kept in the revenue deposit. No matter and the amendment petition
Only question, Mr. Charity, is if there is no award and if there is no deposit, you could never have taken possession. The Land Acquisition Act. So if you are not taken possession,
the amendment is not provided, only the application memo along with amended resolution. On memo with amended resolution is given to me, but I am not aware of the prayer and the prayer.
What document do you have to show that possession has been taken in that background? Yes. 16.2 is only gives rise to a rebuttable presumption if you will have to establish. Please don't let him address arguments. Now you have not passed an award.
According to me, the award is passed.
So produce the award. You have not produced the award.
But the award could not be produced because the time was given to one of the applicants. There are notices to that. But the title, that is why you are only the stack of the rights to us. From then make one more 16 was done.
We will come to 16.2 later, Mr. Charity. Without an award being passed, now we are on a lapse. We are not on.
Now read out the document which says the himself has come and asked for a compensation, which will develop from there. They believe that the acquisition was in the lapse. Now only they explain what he has.
Claiming of compensation will not. He has not taken the money.
He is entitled for compensation.
You have not even passed an award.
According to me,
so please produce the award.
But it is. But that cannot be. He cannot be not to take an advantage of
There must be some cross-reference somewhere. There has to be an award. There has to be a deposit. Only then you can take possession under the Land Acquisition. Otherwise, it's not KDB Act that it vests.
The RTC which has been produced by Chamber, page 48. But the MR entry, 1991. The date when property was more than the property, the
48.
Why am I making it? But from 1991 to aware of that, I'm not justifying the fact that I can take the land without adopting the new procedure without paying the compensation. I'm not that. 1991 is the date from the name of the Bangalore authority. But this is when after 1991, 2017. But he is aware of the fact that the media has allotted the sites to the allottees. There are allottees and they have.
You are mixing the issue about challenge to an acquisition with a lapse. These arguments would be fine if the challenge was to the acquisition. Delay, latches, he was aware of, third-party rights have been created, so-called, are all arguments for challenging an acquisition.
Even if it is the lapse of the land, has to be bought by the land. But 5 years immediately after the right notification, they should, if PDA is not substantially implemented the scheme, but then the other factors from that day, lapse of 5 years is the day when it has to be commencing.
So you mean to say after 10 years he cannot challenge? He has to challenge it on 5 years, 1 day, na?
There is a deeming provision of section 27, which
Either we'll do one thing, we'll call for all the records of BDA. 5 years ಆಗಿ ಎಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗಿಲ್ಲ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಎಲ್ಲ ಕ್ವಶನ್ ಮಾಡಿ. That's not a way that you can say. ನೀವು ಆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಾಳೆ ಶರದ್ ಗೌಡ will file one PIL to say give all the records of BDA 5 years ಆಗಿದೆಯಾ ಸ್ಕೀಮ್ ಆದ್ಮೇಲೆ ಇಂಪ್ಲಿಮೆಂಟ್ ಆಗಿಲ್ವಾ ಎಲ್ಲ ಪಾಸ್ ಮಾಡಿ ಅಂತ ಒಂದು PIL ಹಾಕ್ಬಿಡ್ತಾರೆ ಅಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. Are there any construction put up on that? We asked you last time also. Again, you are arguing the same thing. So produce the documents. You are not producing anything. When be there? You have to produce the award, you have to produce the master for taking possession. ಏನಿದೆ ಏನಿಲ್ಲ ಎಷ್ಟೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರೋದು ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ನೀವು ಹೇಳಿದ್ರೆ ಮತ್ತೆ ನೋಡಿದ್ರೆ ಏನೂ ಇಲ್ಲ. Nothing we have here. That is why we are repeatedly asking you. R2A ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಇಲ್ಲಿ ಏನು R1 ಇಲ್ಲ, 2 ಇಲ್ಲ, 2A ಇಲ್ಲ, ಇಷ್ಟೇ ಇರೋದು. ನಿಮ್ಮ ಹತ್ರ ಆದ್ರೆ ಇದೆಯಾ ಕಾಪಿ? ಅದೆಲ್ಲ ಬೇರೆ ಎಲ್ಲಿಂದಾನ ತೆಗಿತಾ ಇದ್ದೀರಾ, ಅದ್ರ ಜೊತೆ ಇಲ್ಲ. It's not here. No possession notice has been produced. No possession master has been produced. 16(2) notification has not been produced. Allotment has not been produced. Sale deed has not been produced. Status of the land as from today has not been produced. Nothing is here. When you produce all these, produce the sale deed, what is the situation of the property today? Produce the photographs. After arguing for some time, Sri Murugesh Charuti, Lawrence Counsel for the BDA, CH-21 and is granted 2 weeks time to produce the award. ಏನ್ ಮಾಡ್ತೀರಾ? ಬೇರೆ ಎಲ್ಲಾದ್ರೂ ಇರ್ಬೇಕು ನೋಡಿ. Copy must be there somewhere. Copy of the award is available. What is the correspondence you exchange with that? Produce matter. No, we can't say anything in this. Please don't make us say anything. Not as regards an advocate defense. Copy of the award, if any, available. 2, possession notice issued to the award notice issued to the petitioners. Possession master. Details of allotments made with documents in support. The present status of the property along with photographs. We list on 16? 16-8. If you are not able to produce, we'll have to allow the petitioner. Yes.
At that point of time, they approached the developer and the developer protected them. They pending consideration thereof the application they want to be. In meanwhile, they are also made an application for DDA for regular working person. The DDA working. Those sites also got been awarded in year 2003. Subsequently, in year 2009, the subject sites been awarded. Containment of the DDA alerts by using new development since they have been already holding sites in Bangalore. In subsequent allotment of sites is in a violation of the DDA allotment. Therefore, they use this document. Answer the allotment. This is the instance of the respondent is now included. The respondent is
So you had a site or you did not have a site before you have asked for it?
Another, as a normal person, I have applied for allotment of sites in the and the subsequent allotment is 2010. There are on this issue. Whether when sites are allotted considering the application, whether they cannot prevent me from checking allotment of the second or any complaint.
So your contention basically is one is allotment, two is a regularization. So regularization is not a allotment, it will not be bad. It's your contention. No good. Shri Sharad Gowda seeks for and is granted 2 weeks time to make a submission released on 2/8 at 2:30.
If the relinquishment deed is executed, the payment compensation paid.
AGA ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿ ಪಾಸ್ ಪಾಸ್ you go to 26th Tuesday, only Tuesdays. ಇನ್ನ ಟೈಮ್ ಆಗತ್ತೆ ಬನ್ನಿ ಮಿಸ್ಟರ್ ಸುಮನ್ ಏನಾಗ ಅವ್ರ ಆಫೀಸಿಂದ ಯಾರೂ ಸಿಗಲ್ವಾ ನಿಮ್ಗೆ? ಆನ್ ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಇವಾಗ ನೋಡ್ಬೇಕಾದು. ಯು ಹ್ಯಾವ್ ಟು ಸಿ ಇಟ್ ನೌ.
All that is being now produced is the resolution, the decision of the chief commissioner of the BDM to the effect that pursuant to the directions of the government, they are not ready to give us the DDR.
You want time to go through it or you are ready? 19, Learned Council for Respond number 1 has filed 2 memos with certain documents. Copies thereof have been served on the council for the petitioner. The council for the petitioner seeks for and is granted a week's time to go through the same and make a submission. Giving this the matter on 26/7.
Obliged.
Yes, Mr. ಸಿಗಲ್ಲ ಬಿಡ್ರಿ. We will only see, we will say that you have not been able to produce. It has been misplaced at your end. ಮತ್ತೆ ಎಲ್ಲಿಂದ ಹುಡುಕ್ತಾರದ ನಿಮ್ಗೆ? So you issue a document, you execute a document in their favor so that they can use the property. We have adjourned it twice already. Simple thing. ಏನಾದ್ರು ಇದ್ರೆ ನಾವು ಕೊಡ್ತಾ ಇರ್ತೀವಿ. Not for this. ನೀವು ಇನ್ನೊಂದು ವರ್ಷ ಕೊಟ್ರೇನೋ ನೀವು ಹುಡ್ಕಕ್ ಆಗಲ್ಲ, ಸಿಗಲ್ಲ. ಪಾಪ ಅವ್ರಿಗೆ ಎಷ್ಟು ಅಂತ value of the property has gone up pretty, but not able to use it. Execute a document. So petitioner is before this court seeking for the following. The petitioner claims that the petitioner had handed over the original sale deed pertaining to the property belonging to the petitioner in site number 19, formed out of survey number 21 of Gavipura village, Kasbah, Bangalore North Taluk, on 1/5/1980 when the said document had been registered. On 1/5/1983, which has been acknowledged by the respondent by issuance of an acknowledgement. Despite the petitioner having approached the respondent to furnish, to return back the said sale deed, the said document has not been returned back to the petitioner. The petitioner, however, has been making payment of taxes during the meantime, and petitioner continues to be in possession of the property, and there is no encumbrance which has been affected as regards the property. In proof thereof, the tax-paid receipts as also the nil encumbrance certificates have been produced by the petitioner. The grievance of the petitioner is that despite that, on account of the respondent not having returned the original or the sale deed belonging to the sale deed as regards the property belonging to the petitioner is unable to construct a house and or utilize the property, since an application for a plan sanction would require a copy of the sale deed. The petitioner therefore submitted various representations to the respondent to sanction a plan. In the absence thereof, however, an endorsement has been issued at Annexure K that it cannot be done so, and they are unable to return the original sale deed. It is in that background that the petitioner is before this court seeking for the opposite relief. Sri Venugopal ML and counsel appearing for the petitioner submits that the petitioner cannot be made to wait in perpetuity for return of the original document belonging to the petitioner, and thereby depriving the petitioner from making use of the property of the petitioner. The petitioner has been waiting from the year 1983 to put up construction on the property. And for the last 40 years, the petitioner has been deprived of usage of the property, and the property continues to remain vacant and empty, vacant and without construction. So B.S. Sachin, on the other hand, had sought for a short accommodation to verify, trace out the document and furnish the same to the petitioner. However, is unable to do so. In the above background, I am of the considered opinion that grant of further time to the respondent would not serve any purpose. There being no dispute as regards the petitioner being the owner of the property, and the documents, on the basis of the documents which have been produced here, produced along with the writ petition, which have also been submitted to the BDA. I am of the considered opinion that the respondent would be required to execute such document as may be necessary to recognize the title of the petitioner as regards the property bearing number 19 formed out of so and so, in terms of the certified copy of the sale deed dated 1/5/1980, registered as document number 401 of 1980-81 in the office of the sub-registrar, Basunduri, Bangalore. The said document to be executed within a period of 8 weeks from date of receipt of a copy of this order. The respondent shall act on the printout of the uploaded copy so and so. In whom to levy the cost is a problem, Mr. We thought of it. So 1983 in the actually cost impose ಮಾಡಬೇಕು ನಿಮ್ಮ ಮೇಲಲ್ಲ BDA ಮೇಲೆ. Considering that the petitioner has been deprived of using the property for the last 40 years, just to measurement in residential. The property measuring 30 by 40 feet and being residential in nature. And the considered opinion that ನಮ್ಮ ತಲೆಗೆ ಬರೋ ಫಿಗರ್ ಏನು ಬಹಳ ಜಾಸ್ತಿನೇ ಬರ್ತದೆ. Then you should have worked out a remedy for them. You are there as BDA to provide remedy and solution for the, not create obstacles. 40 ವರ್ಷದಿಂದ they are not able to use new, and you don't sanction that for your own default. ಆಗಲಾದ್ರೂ ಓಕೆ ಏನೋ ಒಂದು ಮಾಡ್ಕೊಡ್ತೀವಿ, ನಮ್ದೇ ಮಿಸ್ಟೇಕ್ ಆಯ್ತು, ಐ ಆಮ್ ಸಾರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಆಗಿರೋದು. Uh, 30 by 40 for residential purposes. The petitioner being deprived of usage of the property for the last 40 years, and the petitioner being made to make payment of property tax for the said period without making use of the said property. I have the considered view that ಜಾಸ್ತಿ ಹಾಕಿದ್ರೆ ಅಪೀಲ್ ಹೋಗಿ ಸ್ಟೇ ಮಾಡ್ಕೊಡ್ತಾರೆ. Some more rupees 5 lakhs is required to be awarded. 25 lakhs ಬಂದಿದೆ. 5 lakhs is to be awarded. The said payment to be made by the BDA, and liberty is however reserved to the BDA to recover the same from any errant officials by initiating proceeding against them. They are illa. The payment to be made within a period of 8 weeks from today. 12 weeks from today. Say documented 12 weeks. I mean, ಅದು 12 weeks.
121. If we make another.
Somebody was asked to be present. Deputy Secretary was asked to be present. Then you should have mentioned it at 2:30, Mr. Kiran. So we could have finished the matter and they could have gone and done their work. Yes, what are the documents that you have produced? Have you seen it, Mr. Vikram? Page 34. Yes.
Number 8 was which is now known as normal site version now. Site equals option.
No, are they also pointing to the same plot?
Yes. Yes.
The immediate section has already set the file. We made it to amend the intermediate set at 8.2. But the detailed section rejected it, stating that there is an investigation going on.
We are not concerned with all that. We are concerned with when you auction the property, what is the property earmarked, identified and sold and auctioned?
8 euros.
Is the same property that the petitioner is claiming now?
Yes, sir.
Then what is the problem in executing a sale deed?
When I requested for recording of Prata, then he was informed that in respect of right number 8, there is already a Kata existing, therefore we can't make a Kata. But there is a discrepancy in assigning the site number 8. But site number 8, which is now of option, is a corner site. But now kindly come to answer page 33, which is the possession certificate issued in respect of site number 8/1. If the Lordship could see that that's the position, annexure J and annexure K.
Annexure J ಅಲ್ಲಿ ಏನಿದೆ?
Annexure J is a site which possession certificate is 8/1. Right, 8/1.
Yes.
Kindly see the schedule given to 8/1.
Okay, 9.
Site number 9. West Road. North, site number 8. South, site number 8/2.
This is as regards 8/1.
Yes, ma'am. Now, if this schedule is compared with this case,
Then it will go up to that property, not below.
yes, either the present site which was auctioned should have been assigned with site number 8/2. 8/2, because 8/1 towards the southern side of 8/1.
What is the basis of naming or numbering the site as 8, 8/1, 8/A, 8/B? Why can't it be a continuous number? What is the purpose of numbering? It has to be sequential. ಒಂದಾದ್ಮೇಲೆ 2 ಬರುತ್ತೆ, 2 ಆದ್ಮೇಲೆ 3 ಬರುತ್ತೆ ಅಂತ. ಇವಾಗ A, B ಅಂತ ಬಂದ್ರೆ one can have A to Z. One AA, BB ನೂ ಬರ್ಬೋದು. ನಾವು ಪೆಟಿಷನ್ ನಂಬರ್ ಮಾಡ್ತಿರಲ್ಲ. There is no end to it. What is the purpose of numbering? So why do you have bar 1? Bar 1 could be again bar 8/1000 ಆಗ್ಬೋದು. If we extrapolate it. 8/1 ಇಂದ 8/1000 ವರೆಗೂ ಇರ್ಬೋದು. ಒಂದು ಲೇಔಟ್ ಅಲ್ಲಿ ಒಂದೇ ಸೈಟ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ 1500 8/1500 ಮಾಡ್ಬಿಡ್ಬೋದು. ಹಿಂಗೆ what is the system that you follow for numbering? ನೀವು ಹಿಂಗ್ ನಂಬರ್ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ಎಲ್ಲಿದೆ ಏನಿದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ಬೇಕು? ನಂಬರು ಕ್ರಾಸು ಮೇನ್ ಎಲ್ಲ ಒಂದೇ ಇರಬೇಕು. ಅದೇಂಗ್ರಿ ಒಂದೇ ಸೈಟ್ ಆಗತ್ತೆ ಇದು? ಆಗತ್ತಪ್ಪ. 8 meters by 6 meters. Purva Pashchima 8, Uttara Dakshina 6. So you are saying 42 meters by 8 meters on the site. Railway compartment ginta
and it became a part of site number 8. So they have divided that site over. I just give the out and
ಎಲ್ಲಿ ನೋಡ್ಬೇಕು ಇದರಲ್ಲಿ?
site number 8 ಅಲ್ಲ. Just ಅಲ್ಲ ಅದೇ
ಹಾ
ಮೇಲ್ಗಡೆ portion ಅಲ್ಲಿ ಶ್ರೀನಿವಾಸಪುರ ಅಂತ ಇದೆ. That when the plan was sanctioned, that was not acquired. Subsequently acquired, it became a part of site number 8. That's why they have divided it into different sites over.
ಅದೂನು ಮಿಸ್ಟರ್ ಕಿರಣ್, ಕೆಳಗಡೆ 8, 9, 10, 11, 12 to 15 ಇದೆ. ಮೇಲ್ ಅಕ್ವೈರ್ ಮಾಡಿದ್ರೆ ಬೇರೆ ನಂಬರ್ ಆದ್ರೂ ಬರ್ಬೇಕಾಗಿತ್ತ? ಮತ್ತೆ 8 ಹೆಂಗ್ ಬರುತ್ತಲ್ಲಿ? How can it be part of it? It could have been part of any of those 15 ಆಗ್ಬೋದಾಗಿ. But 8 ಅಂತ you auctioned 8. Now 8 is already here, which is next to a 12-meter road. And you have collected money from him and not executing, giving them khata usage. ಏನಿಲ್ಲ. ಇದು ನೀವೇ ಮೊನ್ನೆ ಆಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಎಷ್ಟು ದಿನ ಆಯ್ತಪ್ಪ?
2018, I have paid 49,57,000.
ಎಷ್ಟು ಹಾಕೋಣ ನಿಮ್ಗೆ? ಇನ್ನ ಮಾಡಿಲ್ವಲ್ಲ, ಎಷ್ಟು ಸತಿ ಅಂತ ಬರ್ಬೇಕು ಅದು?
The DS for an Indian section of center for action for town planning member rejected and keep the presence of town planning member.
ದಿನ over officer. We don't want to call them. Mr. Kiran, for us, you are the lawyer for BDA. ನಿಮ್ಮ ಎಷ್ಟು DS, ಎಷ್ಟು ಮೆಂಬರ್ ಇದು, ಎಷ್ಟು ಡಿಪಾರ್ಟ್ಮೆಂಟ್, we are not concerned.
The town planning member has rejected actually for action it has been paid to us. Whether it will be 21. That is the town sheet. Sarasingari argument for another and Badawan investment in the investment Bola Badawan and Bola. Parishioners are used to the principally argument for another blocker, Badawan and the investment of the 8 by every Rosina. And the investment of the 8 to move in relation of it. Man, moving ಅಧಿವೇಶನಗಳನ್ನು ಹಂಚಿಕೆ ಮಾಡಿರುವ ಪ್ರಕರಣಗಳ ಬಗ್ಗೆ ಕೈಗೊಳ್ಳಿ ಮಾಡಲು ಆದೇಶಿಸಿರುವುದರಿಂದ ಅದು ಸದರಿ ಪ್ರಕರಣಗಳ ಬಗ್ಗೆ ಎಸಿಬಿ ಅವರು ತನಿಖೆ ನಡೆಸುತ್ತಿರುವುದರಿಂದ ಸದರಿ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈ ಹಂತದಲ್ಲಿ ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವಿಲ್ಲ ಎಂದು ಅಭಿಪ್ರಾಯ ಕಳಪವನ್ನು ಮುಂದುವರಿಸುತ್ತಾರೆ.
ಅದು ಅಲಾಟ್ಮೆಂಟ್, ಇದು ಆಕ್ಷನ್.
ಅಲವಡಿಸಿ 8.1 ಅದು ಎಸಿಬಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದರು.
That is as regards you allotting to people who are not eligible. ಎಲ್ಲ ಕಡೆ ಮಾಡಿದ್ದೀರಾ. What about this auction that you are conducting for issuing public notices? Who authorized this auction again? So shall we ask the ACB to inquire against the commissioner also? We'll ask the ACB to make an inquiry against everybody. You carried out the auction. You carried out the auction.
Engineering members,
So you don't claim any ownership of this land.
so we are asking to be a deputy secretary. It's a woman.
Owner.
No, he's a woman.
How does he exercise ownership right? ಯಾವಾಗ ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳಿ ಇವ್ರ ಮೇಲೆ ಹೇಳಿ ಆಗಲ್ಲ, ನಮ್ಗೆ ರಿಸಲ್ಟ್ ಬೇಕಷ್ಟೇ. We'll impose costs. So without cost, nothing seems to work. You recover it from whoever the rent officers are. So, petitioner is before this court seeking for the following release. The respondent BD had issued an e-auction notification on 22/2018, notifying several sites for sites for sale by way of public auction. One of the sites which had been notified for auction was a corner site number 8, measuring 5.70 meters into 8.20 meters, situated at 11th block, Banshankari 6th stage. The petitioner, having participated in the said auction, was declared as a successful bidder at rupees 49,67,527 and had made payment of rupees 8,42,527 on 16/3/2018, and thereafter made the balance payment within 45 days thereafter. Within 45 days. The respondent executed a sale deed on 10/12/2018, which came to be registered on 12/12/2018. And a possession certificate also came to be handed over to the petitioner on 14/12/2018. The petitioner, in order to better utilize the property, had approached the respondent for registration of Tata in respect of the aforesaid auction property. At that time, the respondent refused to issue the Kata, register the Kata and issue the Kata on the ground that there are certain disputes as regards the location and numbering of the property. And as such, undertook to resolve the said controversy. The petitioner, internally, the file was forwarded to the planning member for rectification of the number in conjunction with the location of the property. However, the planning member refused to do so on the ground that there were certain inquiry proceedings which were pending as regards allotment of sites before the Anti-Corruption Bureau. ACBL, right?
Yes.
It is in that background that the petitioner has submitted various representations, and when no action has been taken thereon, the petitioner is before this court seeking for the aforesaid release. Correct. The location of the property, upon service of notice, the respondent presented appearance As per the order dated 5/7/2022, the amended appellant filed its objection. There being no dispute as regards the location of the property, the Deputy Secretary 4 of the respondent had been directed to be present before this court to identify the site from the layout plan, since on the last date the same could not be identified from the layout plan. Today, the Deputy Secretary 4 is present, and upon instructions, Kiran CV Laran Council submits that the property which has been sold in favor of the petitioner is the corner site mentioned in the sketch at Annexure K, which is situated on the southern end of the sketch produced. He submits that the said property has been acquired by the BDA and auctioned by the BDA, and the petitioner is the highest bidder for the said property, and the sale deed has been executed. He submits that though a request had been made to the town planning member for correction of the mistake and issue a registration of Tata in favor of the petitioner, the same has not been done by the town planning member. I have the considered opinion that this is an internal matter between the BDA, and this court cannot be concerned with the different departments in the BDA doing their work or not. It is the BDA who is represented in the present matter, BDA who is represented by the commissioner in the present matter, and it is for the BDA to have performed its obligations and not take up contention of internal departments which are required to perform their obligation. The auction having been conducted in the year 2018, the petitioner has been unable to use the property till now for nearly 4 years. It is but required that when the BDA auctions the property, necessary documentation is completed at the earliest, at any rate within a reasonable time thereof. The same not having been done, the petitioner having paid nearly 49 lakhs, $49,67,527 in March 2018. In the year 2018, the petitioner has been made to run from pillar to post to make use of his property. In view thereof, I am of the considered opinion the respondent would also be liable to make payment of damages to the petitioner on account of the delay caused by the respondent. As such, I pass the following order. Writ petition is allowed. Respondent, a mandamus is issued directing the respondent to execute necessary deed of rectification so as to identify the property auctioned, as also to register the kata in respect thereof within a period of 12 weeks from today. The respondent is also directed to make payment. The respondent shall also make payment of a sum of rupees 5 lakhs as compensation to the petitioner for the non-utilization of the property for the last 4 years. The respondent, the commissioner, is however at liberty to recover the same from the errant officers.
Sanction plan not to include the.
Who is appearing for respondent? Mr. Kiran, or 5 lakhs account ಮಾಡಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. 5 ಲಕ್ಷ ಅಕೌಂಟ್ ಮಾಡಿ ಕೊಡಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. ರೆಡಿ? ದೇವೇಂದ್ರ ಅಲ್ಲ ಏನ್ ಕೇಸ್ ಗೊತ್ತಿಲ್ಲ, ನೀವು ಫಸ್ಟ್ ರೆಡಿ ಅಂತ ಕೇಳೋದು, ಇವಾಗ ಹೇಳ್ತಾರೆ ಮಿಸ್ಟರ್. ಎಸ್ ಮಿಸ್ಟರ್
application for change of land use not visited on the ground. That if the modified sanction plan not issued in favor of the fourth responding issue as a part,
But the fourth respondent had got land acquired. But that acquisition, so far as my land is concerned, was caused by the subject right to the Supreme Court. So it appears by mistake, but my land is not as a park in their sanctioned land.
By mistake.
Perhaps right, because the land is, in the pendency of the proceedings, the land has been sanctioned.
When the challenge to the acquisition proceeding, when the challenge to acquisition proceedings are pending, you are a party to it. ಮತ್ತೆ ಗೊತ್ತಾದ್ಮೇಲೆ ಅಕ್ವಿಸಿಷನ್ ಕಾಸ್ಟ್ ಆಗಿದೆ ಅಂತ ಚೇಂಜ್ ಮಾಡಬೇಕು. Not required. Who is he? You know it is cost. Can you say it is park? You also have no right. ನಿಮ್ಗೆ ಎಲ್ಲಿಂದ ರೈಟ್ ಬರಬೇಕು? Sorry. Petitioner is before this court seeking for the following reliefs. The petitioner is essentially the absolute owner of property bearing number 11/2 situated at Tugrali village, Vattur Road, Bangalore East Taluk, measuring 1 acre 24 gunters. The said property of the petitioner was proposed to be acquired for the purpose of forming a layout by respondent number 4 by issuance of a notification of section 4(1) of the Land Acquisition Act on 26/3/1990. A final notification came to be issued on 15/8/1991. The said notification was challenged by the petitioner's father in WP number 3057 of 1992. And this court, by order dated 6/11/1996, had quashed the said notification in respect of the property of the petitioners. Agreed by the same, respondent number 4 had filed a writ appeal in WA number 67 of 1997, which also came to be dismissed by the division bench of this court by its order dated 17/4/1998. Respondent number 4 preferred a special leave petition in appeal civil number 6288 of 1999, which also came to be dismissed by the Honorable Apex Court on 10/9/2004. Thus, from the said date, the petitioner's father continued to be in possession, occupation, and enjoyment of the property, and subsequently, by the gift deed dated 19/2/2004, gifted the same to the petitioner. The petitioner, having got the revenue records transferred in his favor, had also obtained a conversion from the Deputy Commissioner in terms of section 95 of the Karnataka Land Revenue Act on 17/11/2008. The property being shown as high-tech industrial area in the revised master plan 2015. The petitioner submitted an application for development of the said land, for change of land use from high-tech industrial area to residential zone, while his application dated 23/9/2020. The said application came to be dismissed after nearly a year on 22/2/2021 on the ground that the land as regards with the change of land use had been sought for has been denoted for a park use in the layout plan sanctioned in favor of respondent number 4. RMP high-tech.
Part of it is shown as, because it was shown in the modified plan of the subsidiary unit as part. A part of it is shown also in the RMP unit.
And further, that a portion of the property has been shown as park zone in the RMP on the basis of the layout plan sanctioned in favor of respondent number 4. It is in that background that the petitioner is before this court seeking for the opposite relief. Senior Dragon, that a senior counsel appearing for the petitioner, would submit that when the acquisition itself has been quashed, the question of the respondent denoting the property and or demarcating the property in terms of the plan sanction in favor of respondent number 4 as park zone and or refusing to change the land use of the petitioner from high-tech zone to residential zone is impermissible. The respondent being fully aware of the acquisition having been cost, the respondent ought to have considered the application for change of land use beyond the acquisition proceedings by considering that the petitioner is the landowner and not referring to any rights of the respondent number 4 or any plan sanction obtained by respondent number 4. More so since the said plan sanction in respect of the land of the petitioner cannot hold any water since the acquisition is spot. Shri Kiran CV, Learned Counsel, appearing for respondent number 2, submits that. Park zone doesn't lapse. Park zone is only for layout our relinquish madbe. Lapsing question is barala. When it is shown as park in this one, you have to take a relinquishment deed. You have not taken a relinquishment deed. You never gave it to them to relinquish. 69 barala. Very unsubmission. You are saying it's as per the plan. That is not it. Don't get now observe made katta very matter. Submit that since the respondent number 4 society has not come forward, the plan has continued and the same was incapable of being modified. And as such, the BDA is considering the said layout plan which has been sanctioned and has been unable to process the application of the petitioner. Third, Shri Srinivas Raghavan, Indian Shri Devendrappa, Learned Counsel, appearing for respondent number 3, submit that he is a formal party and there is no submissions to make. None appears for respondent number 4. Third, so and so. The sole basis on which the application for change of land use of the petitioner has been rejected is admittedly on the basis of the land of the petitioner being shown as a park zone as a park area in the plan which had been obtained, which had been got sanctioned by respondent number 4 from the BDA at the time of forming a layout. Correct. At the time when the layout plan was sanctioned, the acquisition had been completed but was under challenge. The sanction of the plan was premised on the basis that the acquisition is complete. However, subsequently, the acquisition had been challenged. The single judge of this court had quashed the acquisition, which has been confirmed by the division bench and finally confirmed by the Honorable Apex Court as detailed supra. In that background, the land never being acquired, the question of the same forming part of the plan sanction submitted by respondent number 4 would not at all arise. When the said land would not form part of the layout under the layout plan, the question of designating the same as park zone and in turn reflecting the said designation in the RMP 2015 formulated by the BDA would not at all arise. Admittedly, there is no independent mind which has been applied to the designation of the land either as park zone or otherwise, except to refer it back to the demarcation and designation as a park zone in the layout plan obtained sanction of by respondent number 4. In that background, the very basis of designation of the land as a park zone being does not surviving and being eroded, I have the considered opinion that the BDA ought not to have referred to the said plan sanction to reject the claim of the petitioner insofar as the park zone is concerned. As regards the change of land use from high-tech to residential use, the same is required to be considered on its own merits by the respondent BDA on the petitioner, fulfilling all the requirements there. Hence, I pass the following order. Writ petition is allowed. A certiorari is issued, the impugned endorsement bearing number so and so, dated 22/2/2021, by respondent number 2 at Annexure A is hereby quashed. A mandamus is issued, respondent number 2 is directed to consider firstly modify the layout plan sanction in favor of respondent number 4 by deleting the land of the petitioner therefrom. And in this regard, whether respondent number 4 cooperates or not. Consequently, respondent number 2 is directed to carry out necessary rectification in the RMP 2015 and reconsider the application of the petitioner dated 23/9/2020 at Annexure L within a period of 6 months. 6 months at yes, what is the time for CLE?
2 months.
Deemed. So
So
total process is 6 months. Then it becomes deemed. Deemed illa CLE within a period of 6 months. Within a 6 months from the date of receipt. The Act provides for all the response. The Act provides for that time, Mr. Rajan. Can't help. 6 months from today, it will act on a printout of the uploaded copy. We are not insisting on any objection from anybody. You care about alternate side. Third, petitioner is before this court seeking for the following reliefs. Petitioner, the owner of the site bearing 1584, situated on 7th block, further extension of M. Vishweshwaraya Nagara layout, Bangalore, and been allotted the said property by the respondent on 6/2/2004. As regards which the entire consideration has been paid by the petitioner and Khata has been registered in the name of the petitioner. When the petitioner had gone to the property on 21/11/2004, the petitioner was informed that the erstwhile owner of the said land had not surrendered the property and that the said property was under litigation. Hence, the petitioner made a representation on 15/5/2010 for allotment of the alternate site. The respondent had replied by endorsement dated 14/6/2010 that the said application would be considered and the alternate site would be allotted. However, no action was taken. As such, the petitioner issued a legal notice on 23/2/2009, followed by another notice on 3/6/2020, which did not evoke any response. Hence, the petitioner is before this court. The petitioner having been allotted a site and the said site not being capable of being used by the petitioner on account of the earlier landowner having challenged the acquisition. And taking into account the submission of Sri G. Lakshmi Shral and counsel for the respondent that the said property has been allotted to the so ಇವಾಗ ಆ ಪ್ರಾಪರ್ಟಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ ರಾಜೀವ್ ಗಾಂಧಿ ಹೌಸಿಂಗ್ ಹೋಗಿದ್ಯಾ ಓಕೆ is being considered for regularization on account of the applications being submitted by the landowners in possession under the Ashraya scheme and allotted to several of them. The respondent BDA does not have possession of the property to allot the same. I have the considered opinion that these facts being to the knowledge of the BDA ought to have allotted an alternate site immediately on coming to know of the same, instead of making the petitioner run from pillar to post for the last 12 years. Admittedly, the first representation had been made on 15/5/2010, and the BDA was aware of the fact that this said property is being utilized by the state for allotment by regularization. Right. So why should he suffer? ನೀವೇನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. ಇವಾಗ ನಾಳೆ ಕೊಡ್ತೀರಾ ಸೈಟು? ಇವಾಗ ಹೋಗಿ ಕರ್ಕೊಂಡು ಹೋಗಿ ಕೊಡ್ತೀರಾ? ಇವಾಗ ಕೊಟ್ರೆ ಕೊಡಿ, ಅವ್ರು ವಿಲ್ ಬಿ ಹ್ಯಾಪಿ. You will be happy to take it. ನೀವಿಬ್ರು ಜಗಳ ಆಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು? ಅಲ್ಲಿ ಆರಾಮಾಗಿ ಕೂತಿದ್ದಾರೆ. You can't make him suffer.
That's in the list. We have prepared a list of alternate site allotments.
Look at the situation. 16 years. 16 years. Who is going to refund the taxes that he has paid? You have received it. Your state government has received it. Who is going to refund? ಅಂತ ಸೈಟ್ ಯಾಕೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ? There's all a difficulty because you have messed up, not for any other reason. And who suffers is a very Mr. Lakshmish, for any other person, private developer, everything RERA ಇದೆ. ನಿಮ್ಗೂ RERA ಅಪ್ಲೈ ಮಾಡಬೇಕು. ನಿಮ್ಗೆ RERA ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ all your offices will be in jail. All. Each of these things is a punishable offense, penal offense under RERA. BDA apply ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಏನಾಗುತ್ತೆ? You are not thinking like that. We will observe that. The petitioner has been left out. The petitioner having been allotted the property in the year 2004, till date, the petitioner has not been able to use the property despite the passage of 18 years. And even till date, the representation submitted in the year 2010 is awaiting consideration by the BDA. There cannot be any excuse for such a delay. Hence, the respondent is directed to, hence I pass the following. Hence, the respondent would also be liable to compensate the petitioner for the said delay. Hence, I pass the following order. A mandamus is issued directing the respondent to allot an alternative site to the petitioner within a period of 6 weeks from today. The respondent is also directed to make payment of a sum of rupees 2 lakhs as compensation, which would probably cover the property tax which has been paid by the petitioner on the opposite property. Who is going to pay him the money? From the year 2004 till date, the state of Karnataka would also have to consider the applicability of the Real Estate Regulation Authority Act to authorities like the BDA. Because the BDA is also a developer of property and involved in development and sale of the property to third party, individual or private citizens. Learned AGA is directed to bring the above order to the notice of the Principal Secretary, Urban Department, where I have after so on. Tax ಆದ್ರೂ ವಾಪಸ್ ಹೋಗತ್ರಿ ಅವ್ರಿಗೆ, ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡಿರೋದೇ ಕೊಡ್ತಾ ಇರೋದು ಅಷ್ಟೇ. ಕೊಟ್ಟರೆ ತಾನೆ, ಇನ್ನ ಯಾವ ಕೊಡ್ತೀರೋ ನೋಡೋಣ. ಕಂಟೆಂಪ್ಟ್ ಹಾಕೋರ್ಗು ಏನಾಗಲ್ಲ, ಹಾಗೆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿ. What is your submission? So
and then they say multi-story building some private property are there.
So again identify ಮಾಡ್ಕೊಡ್ತೀರಾ, ಏನ್ ಮಾಡ್ತೀರಾ? Objection ಹಾಕಿ ಐಡೆಂಟಿಫೈ ಮಾಡ್ತೀರಾ? ಇವಾಗ ನೀವು ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಇದ್ರೆ ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು? 2005 ಅದ್ಯಾವ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದ್ದು? Counsel for response seeks for and is granted 2 weeks time to file a statement of objection. In the statement of objection, specific amendments would be required to be made as regards who has put up the construction on the property allotted to the petitioner and when. 16/8. Yes, Mr. Krishna. Years ಆಗಿರೋದು. Auction sale is 1/8/2005. It was registered on 22/8/2005 ಅಂತಾರೆ. 1/8/2005. So 4 ಹೋಗೋ ಚಾನ್ಸ್ ಇಲ್ಲ.
And it's a being yes,
22/8.
Yes, ma'am. Therefore, what the DPP has instructed Tata is the petitioner. And therefore, the petitioner has application before the DPP to issue license and to issue approved plan to construct the building. Thereafter, now the endorsement will be issued by the DPP saying that not the petition site has been implemented for the road. And then the DPP kindly be seen on page 29.
When was it issued as widening?
And it's the deal on April 2006. Thereafter, he made representative before the BDA to allow the alternative site. Thereafter, when they both respond, the executive engineer conducted on the spot, conducted on the inquiry, to which to the spot and prepared the marker and they submitted the report. Another page 32 by kind of scene. ಅದಕ್ಕೆ ಕುಮಾರಸ್ವಾಮಿ ಒಂದನೇ ಹಂತದ ಪಡೆದ ವಾಣಿಜ್ಯ ಅರ್ಹತೆ ನಿವೇಶನಕ್ಕೆ 22 ಸಲ ಪ್ರಶ್ನೆ ಹಾಕಿ ಸದರಿ ನಿವೇಶನ 609 ತರಗತಿ ಆಗಿದ್ದು 14ನೇ ಮುಖ್ಯಸ್ಥರು ಹೊಂದಿಕೊಳ್ಳುತ್ತದೆ. ಸದರಿಯ 14ನೇ ಮುಖ್ಯಸ್ಥರು ಆರ್ಟಿಎನ್ 2017 ರಸ್ತೆಗಾಗಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಸದರಿ ರಸ್ತೆಯನ್ನು ಬಿಬಿಎಂಪಿ ವತಿಯಿಂದ ಅಗಲೀಕರಣ ಮಾಡುವ ಪ್ರಸ್ತಾವನೆ ಇರುತ್ತದೆ. ಹಾಗೂ ಬಿಬಿಎಂಪಿ ಈಗಾಗಲೇ ಸದರಿ ರಸ್ತೆ ಹೊಂದಿರುವ ನಿವೇಶನದಲ್ಲಿ ರಸ್ತೆ ಅಳವಡಿಸಿಕೊಳ್ಳದ ಜಾಗ ಬಿಟ್ಟು ಉಳಿದಿದ್ದರೆ ನಚ್ಚಂಬಂದಿತ್ತು ಮಾಡುತ್ತಿರುತ್ತದೆ. ಈ ನಿವೇಶನಕ್ಕೆ ಬದಲಾಗಿ ಇದೇ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆ ಎರಡನೇ ಹೆಸರಲ್ಲಿ ಭೌತಿಕವಾಗಿ ಖಾಲಿ ಇರುವ ನಿವೇಶನ ಹೊಂದಿದ್ದು ಬದಲಿ ನಿವೇಶನವಾಗಿ ಹಂಚಿಕೆ ಮಾಡಬಹುದಾಗಿರುತ್ತದೆ. This is the report given by the inquiry. Thereafter, one of the matters the auditor committee, wherein the commissioner and secretary and accounts officer and the deputy secretary one each hour participated. The opposition decision to provide the opposition.
ಸ್ವಲ್ಪ ಏನೋ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿದೆ. ರೆಡಿನಾ? ಕನ್ಫ್ಯೂಷನ್ ಇದ್ದಾಗ ಬೇಡ ಇವತ್ತು ಚೆಕ್ ಮಾಡಿ. The issue is only this: the road was taken by BBMP, property was taken by BBMP for a road. Then you agreed to allot to ಮಾಡಿದ್ರಿ, ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟು ಆವತ್ತಿನ ಡೇಟಲ್ಲಿ ನಮಗೆ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರಿ. ಅದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು. ಅಷ್ಟೇ ಇರೋದು. Because once you agree to allot an alternate, you cannot change the amount. It will have to be the same amount. K. Krishna seeks for and is granted 2 weeks time, read on 3/8. So the W take it. ಏನು ಕಂಪೇರ್ ಮಾಡಿಲ್ಲ.
ನೀವು ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿಲ್ಲದೆ ಇರುವುದರಿಂದಾಗಿ he has not deposited any, he has not paid any amount to the
that he is willing to pay the interest. What is the condition that he is not satisfied?
condition is allotment letter. Condition.
And the payment matra. Anything else he is not satisfied.
Then article
domicile certificate. ಎಲ್ಲಿದೆ domicile? ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಅದೇನೇನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. Basraj, you levy 21% interest on them for delay in payment. You levy 21%. So ನಿಮ್ದೆಲ್ಲ ಡಿಲೇ ಅಲ್ಲೂ ನಾವು 21% ಲೆವಿ ಮಾಡ್ತೀವಿ. ಯಾಕೆ? You'll furnish it. ಅಲ್ಲ ನೀವು ಫರ್ನಿಶ್ ಮಾಡಿದೀರಾ ಮಾಡ್ತೀರಾ ಮಾಡಿದೀವಿ ಅಂತ ಒಂದ್ ನಿಮಿಷ wait. The counsel for the court. The counsel for the petitioner submit that he has complied with all the terms of the allotment and he has furnished the necessary documents. He has given 2 weeks time to produce the same. Released on 2/8. And produce ಮಾಡಿ ಅವ್ರು ತೋರಿಸ್ಬಿಡಿ ಕೊಟ್ಟಿದ್ದೀರ ಆಮೇಲೆ ಏನು ಹೇಳಂಗಿಲ್ಲ. ಸೇಮ್ ಪಾಪ ಅವ್ರು ಇನ್ನೂ ಒಂದು ಲೆಟರ್ ಮಾಡಿಸ್ಬೇಕಂದ್ರೆ ಇನ್ನ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅದಕ್ಕೆ. ಒಂದ್ ಲೆಟರ್ಗೆ ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಹೇಳಿ, ಅವ್ರ ಕ್ಲೈಂಟ್ ಗೊತ್ತಿರ. ಒಂದ್ ಲೆಟರ್ ಬರ್ಸ್ಬೇಕು ಅಂದ್ರೆ ಒಂದ್ ಕ್ಲೈಂಟ್ಗೆ ಎಷ್ಟು, ಆ ಕ್ಲೈಂಟ್ ಯಾರ ಹತ್ರ ಹೋಗಿ ಬರ್ಸಿ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೂ ಏನ್ ಮಾಡೋದು. Keshav Agnihotri has entered up. Agnihotri has entered appearance for the petitioner. Registry is directed to delete the name of Shri Jagan Mohan MT and P. Nandakumar as that appearing for the petitioner. Ms. Poonam Patil has entered appearance for the respondent. Registry is directed to delete the name of Shri M.L. Sudev Hegde as that appearing for the respondent. Ready? Yes. Refunded. Refunded andre let us verify. We'll give them a week. If they have not done it, then you will be entitled. They have to show that you actually received. Has it been encashed? You will have to give us proof of encashment, not checks. Checks are prepared and put in a drawer, not encashed. And checks are encashed in somebody's account also. Ms. Poonam Patil, Learned Counsel, submits on instructions that the amounts paid by the petitioner have been refunded to the petitioner. That counsel is directed to produce proof of such refund, including encashment thereof by the petitioner. Released on 2/8. ಕೋರ್ಟನ್ನು ಹುಡುಕಿದ್ರೆ ನೋಡಿ ಎಷ್ಟಾಗ್ತದೆ, ಎಷ್ಟು ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ಸಿಗ್ತಾನೆ ಇಲ್ಲ 410. In which matter? In WP number 20150 of 2050. Yes, 410.
Responded to the based on record, information and state showing the entire layout. The land should be earlier notified and subsequently denotified as not to acquisition.
Let him make a submission.
But the last state of hearing, taking note of the fact that I am not prepared to order, lordship is directed, I try the information state. Within 27 days, the commission will present today. But I have filed this text along with the information stating the land acquired there. The land extension which we have.
When did you file it?
It was filed on Saturday.
Saturday date, you know?
On Saturday.
16/7. Yes, 16/7 is here. Copy of the details, sketch of circle layout. Everything is there, Mr. Shetty.
The same what you said last time. I saw time to buy the first time. If I had not paid the occasion,
No, we wanted this. So this is there. He doesn't need to be present. No, whether you like it or not is a different thing. This was to only come on record, which had not come on record for 1 year. Now it has come. Yes.
Therefore, office is directed to the sponsor, appearing condition has been an information that all surrounding lands have been either dropped for the extension or demarcated. During the 20th century, BDA has illegally executed the exchange in favor of the respondent number 4, exchanging the land belonging to the petition to that of the respondent number 4, and the respondent and state government are also created land belonging to the respondent number 4. The respondent is directed to place on record the information which was mentioned above, and a sketch.
Yes.
And a sketch, showing the entire layout and the land which were earlier notified, subsequently denotified or dropped from the acquisition. No affidavit is filed, no material because the exchange deed which has the land in question which has been acquired, and exchange deed which has been given to the contesting respondent. Without any affidavit. And second thing, just a memo has been filed without saying what has actually happened, where the land is.
The exchange it is not. You will give him time to produce. No, in your statement, it is not mentioned.
They have made out the case, they want to make out the case in 27. Therefore, with respect to the implementation of the skills and the solutions are made. Therefore, the Lord was direction saying that towards the extent of the land which you
The contention is not that. The contention is just a moment. Just a moment. The contention is that you have exchanged the land of the petitioner with respondent number 4. After exchanging it, you have denotified the original, the land which has been exchanged, letting the respondent number 4 have that land.
Denotification happened in the 2010, extended happened in the year 2013, and the sketch which I have produced also marked the denotified land.
So now basically at the end of the day, net effect is the land which has now come to the share of respondent number 4 stands denotified.
The respondent number, the land that we denotified as sold by the petitioner in favor of the respondent number 4, that we have registered daily consideration. That land, my lord, BDA and the constructor have extended the land. No residuary right to left in favor of the petitioner, not be pointed out to place those records to the first petition. As far as this direction, I understand my reading, I understand correctly. Was that since they were making out a case in section 27, therefore they wanted to know rather the allegation of the petition that we have denotified.
1 is 27, 2 is fraud. Is what they are trying to say.
Therefore, what they have done is, I'm not told that. They did not discuss it before the normal court.
Then you file it. You file all that.
One page it doesn't put issue a file the objection. Respondent number 4 in the first petition has queried the objections in detail, stating the same.
So do you want to file anything or you don't want to file it?
Please will file.
You have filed it, in which matter you want to file?
2014 matter we want to file the objection.
Huh?
It is 2021 matter we want to file the objection.
So when will you file it?
2 weeks time we can do that.
Manjunatha LK. You are appearing for Mr. Manju? 4th. R1 yar. We will come to you. Who appears for respond number 1? Yeah, who is respond number 1 in the first matter?
WP number 1180.
1180. Respond number 1 is. Oh, you are appearing now. Shri B. Vachan has entered appearance for respond number 1 and 2. Registry right, delete the name of Shri Manjunatha LK as that appearance for respond number 1. Respond number 3. Who is for respond number 3? Mr. Rupesha, you are appearing. Have you filed your objections? You that you place. You are appearing for Mr. K. Narayan Swamy. You have filed your objections. What about respond number, proposed respond number 5? You have filed. So only you are left. WP 11080 of 2021. All respondents apart from respond number 1 and 2 have filed their objections. Shri B. Vachan seeks for 2 weeks time to file statement of objection on behalf of respond number 1 and 2. Objections, if any, by 10/8/2022, released on 16/8/2022. In the other matter, you have filed. Anand, you have filed. Interim order earlier granted is extended till next date of yours. 16. Balance.
From what date to which date they are activated and number of days and the percent they are activated and principal amount, everything is in not like we are
29,99,990. They have taken the principal amount as 29 lakh. 9,990. No, other dispute. It is a dispute.
29 lakhs is not
29 lakh. 99,990 is the principal amount. For it is 29 lakhs, 99,990. You 29 lakhs, 69,000 as a calculated formula. And the first lot works up to 3 months interest. Immediately, in the statement of objections, at para 4, they say that the land measures only 80.19 square meters. At para 4 of the return of the statement of objections. So, of this
And then why should we not increase the interest to 21%?
last time they have stated only regarding the interest that they have calculated. How many years they are telling about principal amount?
What I am saying is 25.21 square meters is the reduced area. For that, I have paid.
Whether he says it or not, it is your duty to check what you have to give. There are real work and guest could work on them. You have all accountants, everybody in your office where you demand from the other site owners. Ask to verify Madakagala in officers. Where is the calculation? Your memo does not give any calculation. How many days? What is this the way? Madam, you please. If you persist this, then it goes somewhere else. You appear for BDA regularly. You know how the calculation is made when you make a demand on a site owner. ಹೆಂಗ್ ಕೊಡ್ತೀರಾ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನೋಡಿದಿರಲ್ಲ ಇಲ್ಲ ನೋಡಿಲ್ವಾ ಫಸ್ಟ್ ಈಸ್ಕೊಂಡು ನೋಡಿ ಆಮೇಲೆ ಈ ಮೆಮೊ ಹಂಗೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಂಗಿದೆಯಾ ಅಂತ ನೋಡಿ Why should not we apply rule 13 and say you pay 21%? If your officer's conduct is like this. That is when the petition was filed. Did you pay it on the date when the petition was filed? Yeah, mistake ಆದರೆ ಆಯ್ತು ಮಿಸ್ಟೇಕ್ ರೆಕ್ಟಿಫೈ ಅಂತ ಹೇಳಿ ಸಾಕು. We'll give you time. ಅದು ಬಿಟ್ಟು ಮಿಸ್ಟೇಕ್ ಆಗಿಲ್ಲ ನಾವು ಕರೆಕ್ಟ್ ಮಾಡಿದೀವಿ ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರೆ then it gives rise to all these unwanted issues, not unwanted statements. He is right in making a submission. But these are all unwanted things. The memo has been filed. There is 19/7/2022 as if to explain that the payment made is proper and correct. The counsel for the petitioner submits that the principal amount taken into consideration is wrong, the interest calculation is wrong, and therefore the justification which is sought to be given is wrong. Who is the officer who is making this? Lekkadhikarigalu. The counsel for the respondent is directed to furnish a proper calculation and keep the accounts officer, concerned accounts officer present before this court on the next date of hearing. Released on 3/8. Maniraju? ಫೈಲ್ ಮಾಡಿದ್ರೆ ಯಾವತ್ತು ಮಾಡಿದ್ರಿ? None appears for the petitioner. Learned counsel for respondent submit that he has filed his objections. Counsel registry is directed to verify and place the same on file. We list on 2/8. Mr. Bhargav. None appears for the petitioner. Learned counsel for respondent seeks fund is granted 3 weeks time to obtain instructions or submit his file his objections. Objections, if any, by 11th, relist on 16th. Is not known to be in that particular record. I wrote order 14 rules, order 6 rule 14 AM. And also I make some flight not on that ground. There is an order passed by this court, Mr. Suresh. Please furnish. Shri P.B. Achappa, learned counsel for respondent number 1 and 2 submits that when the respondent tried to conduct an inquiry as directed on 5/7/2022, they did not find the petitioner residing in the address given in the past title of the present petition. Shri Sundaresh HC, Learned Counsel, undertakes to furnish the present and proper address of the petitioner. Yawaga? Within a week from today. The said address to be furnished on or before 25/7. We live on furnishing the address, responding to carry out necessary inquiry and make a submission. We list on 23/8. So, Unnikrishnan. Where is Mr. Unnikrishnan? Appreciate ಮಾಡಕ್ ಅವ್ರು ಇಲ್ವಲ್ಲ. CITB and BDA. CITB receipt ಅಲ್ಲಿ BDA seal ಇತ್ತು.
All the relevant documents for obtained by the yes, it's correct. First document, all the documents under the regulation.
None appears for the respondent. Counsel for the petitioner submit that he has filed a memo yesterday with certain documents. Registry is directed to put up the same. Relist on 2/8.
ರಿಜಿಸ್ಟರ್ ಫೈಲ್ ಮಾಡಿರೋದು
ಮಾಡಿದ್ದಾರೆ. ಅದು ನಮ್ದ ಅದು
ಆಫೀಸ್
ಹೌದಾ?
ನಮ್ದು.
None appears for the respondent. Relist on 2/8. ಯಾರು ಬರ್ತಾನೆ ಇಲ್ಲ. ಬಂದ್ರೆ ರಿವೈವ್. ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಬಟ್ ಬಂದ್ರೆ ನೋಡೋಣ. Despite the order dated 5/7/2022, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter, and the petition is dismissed for non-prosecution. Why dismiss ಮಾಡಿದ್ರೆ ₹500 ಕಾಸ್ಟ್ ಹಾಕಿ ಅಲೋ ಮಾಡಿ. To consider the new representation. ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ?
National direction central court. Court central court to challenge the endorsement. Earlier, what was the reference given? The same reference has been submitted. My management is central court submitted one more representation accordingly that is submitted. To consider.
The petitioner is before this court seeking for the aforesaid relief. While the above matter was pending, another representation dated 7/7/2022 has been submitted. If that be so, it is for the respondent to consider this representation. Shri B.S. Karthikeyan, Learned Counsel for the respondent, submit that the same would be considered within a period of 4 weeks from the date of receipt of a copy of this order. Hence, I pass the following order. Book petitions allowed. Respondent is directed to consider the representation dated 7/7/2022 within a period of 4 weeks and receipt of a copy. Uploaded copy.
75, Kumar.
Achappa. Fourth round. Again, lot of round ಹೊಡಿತೀರಾ Mr. Vasanthkumar. Second round or third round, your fourth round ಹೊಡಿತಾ ಇದ್ದೀರಾ. ಇವಾಗ ಆಗ್ತಾ ಇದೆ. ಕೊಟ್ಟಿದ್ದೀರಾ ಕಾಪಿ? ಮುಂಚೆ ಕೊಟ್ಟಿದ್ರೆ ನೋಡ್ಬಿಡು. ಅದಕ್ಕೋಸ್ಕರ ಅಜ್ಜನ್ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಲ್ಲ ಅಂತ ಹೋಗಿ. Objection is not even, I don't want to read.
My editorial effort for the Bangladesh Chandralaya, for which Malana I got for objective side. So only there are contingent I will not file the application in the state format. That is only the requirement. You can approach another day, under the fourth term is possible given direction to submit the application according to the state format for the BD.
Again, what is your objection?
My objection is the revenue side which is claiming to be acquired by, for which award has been received. And he will purchase the property subsequent after the notifications, preliminary and final notifications.
So his vendor has received the compensation.
Yes, his vendor has received the compensation. And he does not furnish it related to the court or any court for that matter in all the he comes and makes arguments before the court without substantiating the document. And makes a claim for the alternate side of the for the revenue side. Revenue side of that nature, alternate side cannot be provided as standard.
Where is your sale deed? First question is nim sale deed alli. ಇಲ್ಲೆಲ್ಲಿದೆ ಸೇಲ್ ಡೀಡ್? ಅವ್ರು ಹೇಳ್ತಾರೆ ನೀವು ಫಸ್ಟ್ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ.
First contention ತಗೊಂಡಿಲ್ಲ, first petition ತಗೊಂಡಿಲ್ಲ, ಎರಡನೇ petition ತಗೊಂಡಿಲ್ಲ, ಮೂರನೇ petition ತಗೊಂಡಿಲ್ಲ. Now he is asking to produce sale deed.
ಇವಾಗ ಇದೆ ತಾನೇ ಸೇಲ್ ಡೀಡ್? ಇನ್ನೇನೇನ್ರಿ ಬೇಕು ನಿಮ್ಗೆ? The counsel for the respondent has filed his objection. The same is taken on record. Should P.B. Achappa submit that the sale deed on which basis the petitioner lays a claim on the revenue side has not been produced? Shri S.T. Vasanthkumar seeks for a week's time to produce the sale. Relist on 3/8. Produce ಮಾಡಿಕೊಟ್ಬಿಟ್ರೆ ಮುಗೀತಾ? Registry ಅಲ್ಲ. Pujari, none appears for the petitioner. Released on 23/8.
77.
Bandari. Dismissal. Dismissal. Okay. Despite the order dated 14/6/2022, none appears for the petitioner today also. It appears not interested. You filed your objections? You rejoined the application. The counsel for the petitioner seeks and is granted 4 weeks time. EC 23/8. Vanta file. Ajay is here.
I appear.
Ajay, you are not well.
I am not well.
File Vanta.
Please, Milord.
Have you received the file?
Within 2 days, I am going to receive the soft copy, is what I am told. I'll file my statement in a short time. 10 days time.
Counsel for respond number 1 and 2. submit that that you would be receiving the file from the ACV even in a week's time. He seeks for and is granted 3 weeks time thereafter to file a statement of objection. Say based on 23(8).
Great.
There is an inquiry which is pending. We can't direct consideration. Serious allegation is now. Let us see what it is. 23(8).
In spite of that, and I gave a representation as far as the district and in spite of that, the other four petitioners are all allotted site even 2005, except me, that I'm the petitioner. I do not know the reason for this known to the respondent. I have not been allotted by the third for property. Direction to allot the site in part as is done in other cases.
Yes, Mr. Reddy. Yes.
The requirement was to register himself as an person eligible for allotment of the site. He is not registered in this one. Second aspect is that he should be the resident of Bangalore. But that is also not. He is person is staying in Hyderabad. That is why there is a requirement of registration. I have asked for the particulars. Is there any format for that? In fact, my first application was rejected because it was not in the prescribed format. Whereas I find another petition where they said, the court said that you furnish the required format. What is that required format? I just again asked in my Annex D itself, where they would say that it is a mere request letter is sufficient.
Annex D, page number?
Annex D.
Yeah, where is the reply to it?
BDA. I requested the officer to give the application as per the BDA prescribed format. To submit the application as per the law.
Where is the reply? Where is the reply? Where is the reply to it? Where is the reply to Annex D? Reply to Annex D. You asked for a format. Yes, but no reply has been received.
No reply has come. And whereas the other two petitions were not effect that was executed also in the year 2013. And actually, as far as I am concerned, neither there is any reply till now. And in spite of my notice, in spite of several requests, nothing has been done. Have your lordship right there, the other case, this is reply of the petitioner, where there is no reply from this.
Mr. Charati, give him the format. Give him the format.
But the format is given that in the printed form, you may request two requirements need to comply. But that only then he become eligible.
Till you allot a plot, is he to be in rented property? You want him to be in Bangalore. He has been following with you for the plot. You don't allot. Merit Samil Nodana. Application kodi. You decide the entitlement before the application or after the application? You decide the entitlement before or after? Otherwise you don't. Then you can't say that he has not submitted in prescribed form.
Why am I saying submitting this? But these are the people who are considered which were acquired compensation because they come and challenge the acquisition. And what this one goes to the lenient view that some of the people who had wanted to put up the assessment of consensus and maintenance of but such people should not be described as a site. That is why this directive was given. We make an application to the Bangalore Development Authority. It's not as a matter of right to provide it to them. It was a discretionary order.
The contention here is not that. Your contention that you are making is that he did not submit in the prescribed format.
Yes.
Now, for the prescribed format, you say that he has to establish his right, then you will give the prescribed format. So the question of him making it would not arise, number one. Number two, this court, while passing the order, did not say prescribed format or you have to adjudicate Allah. They only submit, you have to decide. Then you have to give the prescribed format without inquiry. Our rules say.
In fact, my first application was rejected because it was not in the prescribed format. Even
Not for any other reason.
Even they said it's not a prescribed format, it is required format. What is a prescribed and what is a required? How am I to know that?
But the form 1, approval 1, approval 7, there is a form prescribed. Wherein what you can kindly see whether the applicant already owns the house or outside in the city with the details, outside the city with the details, not whether the city has been a domicile of Bangalore, ordinarily resident in Bangalore city, in the area under the to report. So all these supposed to be in the format is there.
Did you tell him which format?
Yes, no, it was told by the court in the prescribed form, required form, not prescribed, required form.
When you rejected,
Yeah, right.
when you rejected, did you say which form?
Annexure C, not prescribed, required. The petitioner is permitted to make applications in required format within a period of 8 weeks from today. Required when my first application was rejected, that was a ground of being challenged. But that is all the report saying required format. What is that required format? I just went and asked. They say that there is no such required format. It was the request that we do. Accordingly, I have published all the documents which I wrote inside along with the training. And I just published that along with the court order. If ever required or there is no required, what is the required format or prescribed format?
Can you see the subsequent order?
Annexure C, that was the order.
Which order you want us to see, Mr.
Annexure C,
page 42.
42. Yes.
According to the permitted to make an application in the required format within a period of 8 weeks from today. Required format ordinary resident of Bangalore, and they should not own a site. But this kind of thing, the intention behind passing this order is
Where is the earlier rejection? And please don't interrupt when he is making submission. Please wait. Where is the earlier rejection? Where is the earlier rejection you said was rejected because it is? Where is that rejection? Where have you produced it?
Based on that, the rejection, I challenged it before this.
Where is the rejection order, Mr. Cons? Where is the rejection order? You have not produced it. And you are arguing on that basis.
No, the petition, this is a case where government is trying to pursue this account and the same 42. The petitioner made applications for allotment of site in the beginning of the page 42 law. The said applications are rejected on the ground that they are not in the required form against this petition. And subsequently, if you know, there is only technical error committed by the petitioner and that application should be in the required form. What is that required form? That is not other. When I inquired that, they said there is no such required form.
They approached you asking you for required format. You did not respond to it.
Right? Required format is court, not only in this case, not only in this particular, even in Visa Master, that is a record. But the exact words which are used in the prescribed format is which they should comply with the allotment rules of 1980. The allotment rules of 1984, they say, from my request your
Petitioners shall register themselves as applicants for allotment under the Bangalore Development Authority Allotment of Site Rules 1984. That is clause B of para 3. It's clear. So you are tracing it to Junjama's order. 3B is clear that you have to make it as per that rules. It is not that any special format has come up for you. It's there in the order, you have produced it, Mr. Counsel. You have produced the order. They have your legal advice. Still, you are sending only these letters. Some of these things you should also know. Para D also has the same reference. You have produced at page 35, 36. If you read, you know what is to be done. You should do it. Not him. You should do it. And from 2006, you have been keeping quiet.
2014.
And the first notice you have given is 2020. We can't help you, Mr. Counsel, not in this matter. Petitioner is before this court, seeking for the following. The petitioner claims to be the owner of a revenue site in house list number 108, Kata number 118 at Ajinapura village, Uttaradi Obdi, Bangalore South Taluk, which came to be acquired for the purpose of formation of the Ajinapura layout. The petitioner therefore sought for regularization and allotment of developed land in view of the acquisition of the said plot. An application being in terms of the decision of this court in Junjamma's case, ILR 2005, Karnataka 106. The application filed by the petitioner came to be rejected by the respondent, which was challenged in WB number 3821 of 2006 by the order dated 3821 of 2006, which came to be allowed by order dated 7 December 2006, permitting the petitioner to make application in the required format within a period of 8 weeks. And if such application are made in the requisite format, the BDA was directed to consider the said application. Despite the said order having been passed on 7 December 2006, no action has been taken by the petitioner, except to once approach the respondent seeking for a format on 5/1/2007. The next action taken by the petitioner was only on 25/2020 by issuance of a legal notice. In view of the above, I will consider the opinion that the indulgence which had been extended by this court, by order dated 3821 of 2006, has not been availed of by the petitioner, and the benefit provided to revenue site owners and in Junjamma's case, which was also which was required to be availed by the revenue site owners within a given time frame, not having been availed of the present petition solely on the ground that the format has not been made available to the petitioner is not sustainable. This being so, also for the reason that both in Junjamma's case and several other decisions, this court has categorically held from time to time that the revenue site owners would have to register themselves as an applicant for allotment of site under the Bangalore Development Authority Allotment of Site Rules 1984 and comply with the requirements thereof. The orders being clear on this point, the petitioner was aware of all these aspects. As such, I am unable to accept the contention of the counsel for the petitioner that the petitioner is not aware of these details and is still awaiting the format of the application for the last 16 years. Hence, there being no grounds made out in the present petition, the petition stands dismissed. Counsel for the petitioner, Shri where appear Shri Sandeep Patil has entered appearance for R1 and R2, delete name of B. Vachan. Counsel for the petition seeks for and is granted 3 weeks time, released on 16/8.
My lords, I'm
16/8.
the respondent number 1 and 2, my lords.
Yeah, you file your have you filed your objections?
My lords, 2 weeks time may be granted to file my
Objections of respondent to be filed in the meanwhile. Repeat ಅದು ಹಾಕಬೇಕು ಇನ್ನ ಫೈಲ್ ಮಾಡಬೇಕಾ ಹಾಕಿದ್ರೆ ಅದು ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾನ್ಸ್ ರಿಲೀಸ್ಡ್ ಆನ್ 16/8. ಗೋಪಾಲ್ ಹಾಕಿದ್ದಾರೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್. Though the counsel for the petitioner is present, none appears to respond. 3 weeks time is granted to respond to file its objection. Objection is written by 16th, released on 23rd. Mr. Basraj. Ready na? ಎಲ್ಲ ಬಸವರಾಜ್ ಅವರು ಎಲ್ಲದರಲ್ಲೂ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. ಸಾರಿ ಟು ಪುಷ್ ಯು ಬಟ್ ವಿ ಕ್ಯಾಂಟ್ ಹೆಲ್ಪ್ ಇಟ್. ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದ್ರೆ ಇಷ್ಟೆಲ್ಲ ಆಗಲ್ಲ. About alternative land. Any objections?
Empowered to direct the BDA to allow to article land which has been decided to intervene. Not only allotment of article land. Three times allotment has been issued, okay? Only thing is there is a dispute. Whatever they have granted the land, it is under the dispute. And there is also alternative land. That is only my view.
This will require hearing will ಆಗೋಯ್ತು ಟೈಮ್ ಇವತ್ತು ಬೇಡ ಎಲ್ಲ ಅಜೆಂಡ್ ಮಾಡಿ only writ of mandamus ಅಲ್ಲ there are 2 judgments also passed. You will have to go through that. 84 released on 16/8.
85 my lords. This matter be called my lords after 4 weeks.
Objections you have filed, Mr. Ajay?
My lords, sorry. My lords, the very question which is now raised is now being considered before the division bench in writ appeal number 956 of 2021. Matter is reserved for judgment. This will be called after 3-4 weeks.
85 learned counsel for respondent number 1 and 2 submits that the present matter in issue in the issue in present matter is drawing the consideration of the division bench of this court, where arguments have been heard and the judgment reserved.
Please.
And they submit that the matter will be adjourned by till the 4 weeks. Released on 23/8.
Please.
Objections ಹಾಕಿದ್ದಾರೆ. None appears for the respondent. Counsel for the petitioner is present. None appears for the respondent. Objections are yet to be filed. 3 weeks time is granted. Objections 20 by 16. Released on 23rd.
87 appearing for the petitioner, my lord.
Yes.
My lord, we have received the file today. We have filed NOC Wakalat. I'm appearing for Yashu Mishra, my lord. Kindly grant a short date.
Yashu Mishra has entered appearance for the petitioner. Registry is directed to verify and print his name as that appearing for the petitioner. Shri Unni Krishna has entered appearance for respondent number 2 and 3. Registry is direct delete the name of Shri S.N. Prashant Chandra as that appearing for respondent number 2 and 3. Have objections been filed?
My lord, we are yet to verify the same, my lord.
Objections are yet to be filed by respondent number 2 and 3. 3 weeks time is granted. Objection opening by 16. Released on 23rd.
Please, my lord.
88. Mr. Ajay?
My objections are ready. By next Tuesday, matter will be taken up.
So for the petitioner, respondent seeks for and is granted 2 weeks time to file his objection. We list on 16/8.
I'm grateful.
And appears for the respondent. Objections are also not filed. 3 weeks time is granted. Objections venue by 16th, released on 23rd. The counsel for the respondent files a memo along with documents. Affidavit along with documents. The same is taken on record. Copy is served on the counsel for the petition. Nodidra? Kodi avariga copy. Counsel for the petitioner seeks for and is granted 10 days time to go through the same and make a submission. We list on 2/8. So Chickmart. Yes.
This representation has been considered and we gave an endorsement on 24/6, rejecting the representation of the petitioner. After running the endorsement is issued, and for the amendment application,
Amendment application ಹಾಕಿದ್ದೀರಾ? Right, counsel for the petitioner submit that an amendment application is filed, registry is directed, trace out the same and list it. Relist on 2/8. Objections will work. None appears. Objections are yet to be filed. 3 weeks by 16, relist on 23rd.
My lords, I appear for respondent number 2, my lords.
Yes, madam.
My lords, the BDA was actually supposed to come back with a resolution since we had agreed that this could be kept as a park. BDA said they need a resolution passed by its board.
So what happened to the settlement?
My lords, the settlement is we have settled that. Yes, that it should be left as a park, as a public park. And BDA also in principle is agreeable.
Just a moment. Hold your horse.
Sorry.
Mr. Unnikrishnan, you won't hear us with your voice. Mr. Unnikrishnan.
Not sure if he's there.
'94. The counsel for petitioner and respondent number 2 are present. None appears for respondent number 1. Relist on 2. Relist on 28/7.
Grateful, my lords. Grateful.
Relist on 28/7. 28/7. 2/8. 2/8. 2/8. 102, 103, 2/8. 104 to we are adjourning it to 3/8 in Karnataka. 3/8, 2/8. 104 to 112.
That's in 109. I'm sorry to interject. That's
109 and Mr. Ajay.
There was a direction to conduct make the allottee a party. I had to give the details. I have given the details, my lords, of Mr.
That
Shesha.
application is not put up. We'll have it on 212. We list on 16/8.
My lords, if I may be permitted to make a submission, my lord.
Yes, madam.
My lord, serial number 87, there is an interim order persisting.
87
subsisting.
interim order. Yes.
Interim order may be extended.
We will continue to keep it persistent.
Please,
Yes, Mr. Manjunath. You are barely recharged. We can't. Not now. Not now. Not now. Not now, Mr.
Court officer. Court officer, madam.
What up, sir? Sir? 94 देना है सर?
ಹೇಳಿ ಮೇಡಮ್.
112.
94 देना है ಮೇಡಮ್ मेरे
ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಸರ್?
फर्स्ट लिस्ट 94.
94 urgent to 28/7.
28/7 ना? Okay.
28/7.
Okay, thank you.
112, madam.
112 16/8.
Thank you, madam.